Hope everybody had a good evening. I'll just note for the record that two of the petitioners are here. Attorney McDonald, I don't see him yet, always coming in at this point. Three of the respondents are here, all with their clients. Mr. Bourgeois and Mr. Travers, as indicated yesterday, are not here. As I indicated yesterday, I had hoped to do certain things by referring the matter back to the commission, but I'm told that unfortunately that's not a possibility. So I'm precluded from doing so, and I can't do it. So I'll also note, as a housekeeping matter, around 11:15, there's a foreign delegation from Uzbekistan arriving, and Ms. Duca has to meet with them. So we'll be taking a break around 11:15 for approximately half an hour.
Judge, is there any rule prohibiting? I understand that we're not doing it.
Yeah.
Is it for my education?
Yeah, as this is what was indicated to me. I have the authority to refer a matter to the full commission for its consideration. The commission may review any such matter referred to them by deliberating during an executive session of a duly noticed meeting. The open meeting law requires that notice of any such meeting must be posted 48 hours in advance thereof. Further, the transcript of testimony upon which a commission would deliberate has not been prepared or certified because of these legal requirements, and I am unable to provide you this morning with any response from the commission. So there you have it. Thank you. I read the document, which was the statement of Judge Des yesterday, and candidly, I don't see anything overly concerning. I note your objections of the respondents and your own ongoing objections, but I am subject to hearing from Attorney Sullivan by Wednesday. I am inclined to admit it. I will note, however, that there's certain personal information in here, i.e. the judge's personal email address, his phone number. So I'd ask the petitioner and the parties to redact that from the document. I'd ask you also to go through the documents that I've already admitted for a similar review and redaction if appropriate. I assume the parties will be able to agree to that. If not, please bring it to my attention and I will intercede. Thank you.
Judge, on that score, I'm assuming that we were probably going to be dealing with additional transcripts. Can we deal with them here without redaction and redact them after they've gone in?
Whatever's easy and most convenient for you. I just ask that you do it collegially and together. And as I said, if there's any problems, let me know. So with that, we are ready to proceed. As I understand, the petitioners rested yesterday.
Yes, I only had one quick question about the transcript that you're just allowing in. Is that the next exhibit number?
Well, I told Attorney Sullivan I would give him an opportunity to respond. So why don't we do it on Wednesday? Because that's when he's going to get his memo. Okay?
Thank you.
Oh, no.
Judge, I got the citation wrong. You thought I got it right. I cited the wrong section. I've been doing this stuff too long. I had the right subsection.
You were correct in substance of what you were indicating. So with that, I'll turn to, are there any other, I take it there's no other housekeeping matters? Nothing, very good. I'll turn to the respondents, and Mr. Burke, you've always let it off, but I'm assuming today that might not be the case. So
I think we have
Attorney Rusconi, I notice you're standing.
I'm
So.
standing, Your Honor. Yes, we're switching up the order today, so I'll be calling Mr. Tide, and we'll transfer you on behalf of.
Okay. Thank you. Hi, Troop. Good morning to you, sir. Can you raise your right hand? Do you swear to tell the truth, the whole truth, so help you God in this proceeding?
Yes, sir, I do.
Thank you.
Appreciate it.
Yeah, please have a seat. And would you like some water? I can get some water for you.
I have one over there I started. I will grab it.
Yeah, why don't you just, yeah, sure.
Your Honor, I guess I'll preface. I'm going to be moving to admit his Attorney General's transcript. I don't know if you want me to do it now or just wait until the end.
Whatever you want to do.
I suppose I can just ask have it admitted now. I believe it's disputed exhibit 3.
Okay. So it's disputed exhibit 3?
Yes.
Okay. And so you're moving to admit that. Is there any objection?
Only that the respondents all objected to Judge Despotopoulos' transcript coming in because he was on the stand and available for cross-examination. So, I mean, we would make the same objection.
Okay.
Okay, well, we'll agree not to introduce his if you take those back. How's that?
Well, I'm going to allow the parties to discuss that and reach an agreement. So I take it you have no objection to this document coming in?
No, and I think the way that the matter has gone, we've had discussions about transcripts at different points. The objection yesterday was the witness was going to be on the stand. We ought to be able to cross-examine, or the parties ought to be able to examine, knowing, and the respondent, the witness, they're the judge, ought to be able to get questioned on it in, as Mr. Sullivan said, in his interests. From my perspective, Colonel, that's not a promotion. The deputy superintendent has the same kind of rights, and we all ought to be able to examine on that document.
Okay, well, you're obviously the witnesses here, you're free to examine and cross-examine them. And I'll just note that it's Attorney Risconi, one of the respondents offering that exhibit. And once again, I've left just about everything in, and I will let that in. Do we have it?
Yes.
So, okay, I'm going to hand it. Can you just hand it to her?
I believe that is redacted, if it's the same one I have as far as personal info, but I guess just to be safe.
You know what I'll ask you to do when you have a moment, when during the break, yes, sir, can you just give it to her, please? During the break, just review it and just make sure that, it's properly redacted.
I will.
So is this going to be exhibit 3 or is it the next exhibit in order, exhibit 38?
Yeah, this is the next exhibit.
So it's exhibit 38.
Yes. You can leave it there for now. I'll ask him to grab it if you need. Your Honor, may I inquire?
Please.
Good morning, Mr. Hughes. Good morning. Mr. Hughes, can you introduce yourself to the presiding and the commissioners, which I believe are watching?
Good morning, Commissioner. My name is Frank Hughes. My last name is spelled Hughes.
And were you at one point employed in the state police of Massachusetts?
Yes, I was.
Can you go over some of your training as far as that goes?
Well, originally, my original training started at the State Police Academy in 1986. I was a member of the 67th Recruit Training Troop. That training lasted from July to December of 1986. And throughout the course of my career, I continuously was involved in different types of training from the beginning to the end.
So what, if you could just kind of go through what divisions you were in, what units, what training classes?
Every trooper that starts from the state police starts in the Division of Field Services. They're a uniform trooper. They're assigned to the interstate highways, barrack systems. They're responsible for patrolling the highways, responding to crashes, enforcing motor vehicle and criminal laws. I was assigned to the Division of Field Services for 4 years. I started out at State Police Barracks in Athol. I worked in Athol for about 2 years. At that point, I was transferred a little closer to home. I worked out of the Concord Barracks, which is Troop A, and I worked there for about 2 years. At that point, I was recruited to be a member of the Division of Investigative Services. There's a difference between divisions. Some are biddable, just based on your seniority. Other divisions, you have to be chosen and interview for the position. That's the Division of Investigative Services is one of those divisions where you have to be chosen to pick. You're interviewed. At that point in time, former Colonel Thomas Foley was in charge of the Special Services section. I was interviewed and chosen to be a member of the Organized Crime Unit. I worked in organized crime for a couple of years under the umbrella. The name of the unit was called the Special Services section. Special Services section incorporated 3 different parts. It had the Violent Fugitive Arrest Squad, the gang unit, and the organized crime section. So, as well as executive protection for the governor and different state officials. So I worked in that, doing organized crime for about a year and a half, and then the gang unit was expanded. And at that point, it was separated from the Special Services section, became its own unit statewide. And I was assigned to that for approximately from, I'd say, 1992 to 2002. I was assigned there, the gang unit. I was part of a federal task force with the FBI. I was a sworn special federal officer, which provided me some federal powers to testify in federal court. I remained in that position until I took the promotional test for the rank of sergeant. It's a competitive testing process. After the test, I was placed on a promotional list for a period of time to a point where I was promoted to the rank of sergeant, where I stayed in the gang unit as a supervisor of the North Shore Gang Task Force. I remained in that position for several years until I was asked by Colonel Marion McGovern to take a position at the State Police Academy in New Braintree. At that point in time, I was on the lieutenant's promotional eligibility list. I was 3 or 4 away on the list. She asked me to come out to the academy and assist in some transitions that were taking place out there. And that was midway through the 78th Recruit Training Troop. I stayed there through the remainder of that class. There was a class that followed immediately after that, 79th Recruit Training Troop, and I stayed through that class.
So if I could just stop you, so you're teaching young cadets in the academy, correct?
So I was the executive officer, so I would have been the second in command. The commandant of the academy was a former instructor of mine, Detective Lieutenant William Powers. He asked me to come out as well as the colonel, to come out and assist, and yes, I would be involved in some of the training of the oversight, really, of the day-to-day operations. And I did teach some classes while I was there.
If you could continue with your training and background until we get to today.
Upon completion of the academy, I went back to the gang. I was promoted to lieutenant. I went back to the gang unit, statewide gang unit. At that point in time, I became the executive officer of the gang unit, number 2 in charge of the statewide gang unit. We had 6 different units around the state, mostly in urban areas, conducting investigations, gang-related investigations that have to do with drugs, narcotics trafficking, firearms trafficking, commercial B&Es, anything that, any kind of gang involvement, assisting in homicide investigations. Stayed in that position. I took the captain's test. I was promoted to the rank of captain, at which point in time I was transferred back to the Division of Field Services, again, the uniform division of the state police. And I was assigned to the Holden Barracks, Troop C Holden, headquarters station. Now, the Holden Barracks it has a substation and a headquarters station, and that may come into play during this testimony here. Upstairs of the barracks is the Troop C headquarters. The downstairs is the substation where the daily activities take place. I was only there for maybe 4 or 5 months. At which point in time an opening happened to come about in the internal affairs section. I was asked by the colonel to go to the internal affairs section and be the commanding officer of the internal affairs section. That section is responsible for investigations of internal misconduct or alleged internal misconduct of police officers, state troopers, violations of policy procedures, violations of rules and regulations. We stayed there for about 1.5 years, at which point in time I was promoted again to detective captain and transferred back to the Division of Investigative Services. I worked for the deputy division commander at the time, Major Michael Crisp. Major Crisp retired. Colonel McKeon took his place after he retired. The colonel was promoted to major from captain. And I was Colonel McKeon's executive officer, number 2, working for the colonel. He was a major at the time. Some point in time, another opening happened in the Division of Investigative Services, and I was promoted to major, where I worked with Major McKeon at the time. We both basically had we split the state, the investigative units in the state. Major McKeon at the time handled mostly the Western investigative units. I handled the Eastern investigative units. Stayed there for a couple of years, until 2015. We're up to 2015 now. Colonel McKeon had been promoted to colonel. Shortly after him being promoted to colonel, he asked me to come into his office. He interviewed me for the position of Lieutenant Colonel Deputy Superintendent, and I was chosen to be the Deputy Superintendent under Colonel McKeon.
And when you left the state police, that was your rank at the time?
Yes, it was.
Turn your attention to some other, I guess, directives or trainings in the Massachusetts State Police Department. You're familiar with the opioid epidemic and crisis in the United States, are you not?
Very familiar, yes.
Can you tell us a little bit about that?
In my position, well, as a trooper assigned to the gang unit, the majority of my work involved drug investigations, investigating violations of 94C, the Mass General Law involving narcotics, trafficking of narcotics, any type of violation of 94C we were involved in. That's basically, there's no crime for being a gang member. Gang members are involved in narcotic trafficking. So that's how we would proactively conduct investigations to go after these gang members that were conducting street level, open air market drug dealing. During that period of time, I did that for over 10 years. I was involved in thousands of arrests for violations of narcotic trafficking. Anything from possession to trafficking over a certain weight. I had a lot of experience in that, street level dealing, trafficking. In my position as a major and detective captain, I would be involved in receiving updates from our investigative units regarding different investigations, to include unintended deaths. These unintended deaths would include where our CPAC or state police detective units would be called out to a scene where someone passed away as a result of what they would believe to be a narcotic overdose. Myself, at the time, Major McKeon, we would receive a teletype item every single day regarding overdose deaths. At that point in time, for the 2 years that I was a major, we were averaging.
I'm gonna object to this testimony. This case has nothing to do with an overdose death. It does have to do with the changing of an arrest report. So I'm not entirely sure how this testimony is at all relevant to this case. It's not about an OD.
Okay, well, I think we're gonna get closer to that point soon, and that's overruled.
So we would receive daily updates regarding the people that passed away as a result of narcotic, generally heroin or fentanyl overdoses, to the point where we were averaging on a monthly basis between 65 to 70 people passing away from narcotic overdoses a month. Now, that's not including the city of Boston, the city of Worcester, the city of Springfield, or the city of Pittsfield. They do their own death investigations, so that's 65 to 70 people a month, not counting those major cities.
If I could just stop you there. And at this point in time, when you're dealing with all these overdose reports, is Colonel McKeon working parallel to you, just or alongside you, or?
Yes, he's getting these notifications from the western units, I'm getting from the east.
So as a result of all these overdoses, did that affect how the Massachusetts State Police, or did it change the direction in how they were going to handle the opioid crisis?
Absolutely.
You should describe that.
State Police partnered with the Department of Public Health as it related to combating the opioid crisis. There was a crisis, like I said, 65 to 70 people a month passing away from directly related to heroin overdoses or fentanyl overdoses. We started a program where we started training our troopers in the use of Narcan. You know, using Narcan when they responded to a scene and someone appeared to be suffering from an overdose. They were trained on how to administer Narcan. That was something that we rolled out. Also, later as when the colonel became superintendent of the department, we started a new division, the 5th division. It was a pretty big deal. A lot of work was involved in doing it. Traditionally, the state police had 4 units, 4 divisions. We established a 5th division, the Division of Homeland Security. As part of that division, we received funding from EOPS in the state.
What's EOPS?
EOPS is the Executive Office of Public Safety and Security. It's actually located in this building upstairs.
Okay. And so continue in this, again, in the vein of how this changed the philosophy of Massachusetts State Police towards treating people with opiate issues.
So we started attacking, we had a multi-phase approach to attacking the drug crisis. Now, we had officers would respond with Narcan to help assist people. And we would attack it on different levels, street level narcotic dealing, as well as higher level drug trafficking, going after drug trafficking organizations. The state of Massachusetts is basically the source center for narcotic trafficking in all of New England. People come to certain cities in Massachusetts to obtain their drugs. And I can tell you this from my personal experience, most of the narcotics that are found in Maine or New Hampshire come directly from Massachusetts, almost the majority of it. So we partnered with state police agencies and local police agencies, Department of Homeland Security, to try to get a better handle on intelligence on how drugs are working between all over New England. It's a very complicated system on how drugs are trafficked. It's very sophisticated, and we decided to implement a system that we had seen that was successful in the city of Lawrence. This group in Lawrence that we had was under Detective Lieutenant Thomas Quinn had started this program where they would do long-term investigations involving surveillance, using GPSs and different things, court authorized, obviously. And the system worked great. So we incorporated this as part of the Division of Homeland Security, and we developed 3 units statewide, which we call the Commonwealth, it's CINRED, Commonwealth Interstate Narcotic Trafficking, Reduction in Trafficking Team, Enforcement Team.
I'm gonna renew my objection. None of this testimony has anything to do with the change to an arrest report. The opioid crisis has nothing to do with it. The state police using Narcan has nothing to do with it. The trafficking from New Hampshire has nothing to do with anything in this case.
Well, as I indicated, I assume Attorney Risconi is going to bring it home rather quickly.
If you could get into exactly how this affected the state police's approach to people suffering from abuse as opposed to the people trafficking it.
Vast difference.
So could you please get into the abuse part?
People that are suffering from abuse are suffering from a disease. People that are trafficking narcotics contribute to their death. That's the bottom line.
So was there a change in approach on how the state police was handling interactions with individuals suffering from abuse?
State police were treating them more like victims.
Okay. And are you familiar with, I believe it's on the Department of Public Health's webpage, and it's hashtag State Without Stake. Are you familiar with that?
Yes, I am.
And can you briefly describe what that is?
Department of Public Health, along with WCVB Channel 5, conducted a public service campaign regarding institutional stigma that was involved in the trafficking, institutional stigma regarding people suffering from opioids or any kind of substance abuse issues.
Now, when you say institutional stigma, what does that refer to specifically?
Specifically, in this program, referred to how police officers respond to or interact with people suffering from substance abuse. Specifically, terms they use to try to get away from using terms like junkie, addict, things to that effect. It was these terms only kept people from seeking treatment. And this was something that we were trying to change the public perception of people from, for lack of a better term, junkies to people that were sick.
Thank you. In your employment with the Massachusetts State Police, you attended a lot of, I believe, what's called command staff meetings. Can you tell us about what those are?
Yes. Weekly, every Monday morning, Colonel McKeon would have the division commanders, originally 4 and then 5 when we interacted with the 5th Division, come to his office. There would be a weekly meeting to catch up on major events that were going on within the department. It's a big agency. A lot of things are going on at different times. So this would give us an opportunity, the colonel, to get briefed on what each division was doing, different protocols that they were involved in, projects, things to that effect.
Any particular command staff meetings jump out to you as significant?
Well, there's really 2 types. There's the weekly meeting, and then there's quarterly or biannually. The colonel would have a major command staff meeting that would involve not just the division commanders, but troop commanders and investigative heads, the commanders from the different investigative units come into one room, and it would be a couple hundred people, all commanders within the department, and there would be a command staff, that would be a total command staff meeting.
Now, in the fall of 2017, was there any command staff meeting like you just described?
Yes, it was.
Can you tell us a little bit about that?
This command staff meeting was held in Commonwealth Fusion Center in Maine, Massachusetts. Each troop commander, division commanders were there, each troop commander was there, head of all the investigative units, state police detective units. Anyone that had a major role in oversight or supervision was at this meeting.
And who was the person presenting at that meeting or speaking at that meeting?
Well, the colonel would start, he'd go over different things that were on a list, that topics that he was concerned about. Then each division commander would basically have something that they'd want to say regarding more or less what the colonel's major directives were.
At that meeting, do you recall anything the colonel brought up of any significance?
Yes, he did.
Can
Yes,
you
he did.
describe that?
Colonel was very concerned about the way reports were being written within the agency. Very concerned about it.
Judge, can you just have a rough estimate as what the date was on this? I heard 2/17.
Yeah, he did say 2017. You want something more specific?
Yeah,
I think it's
Okay.
in the fall of 2017.
I believe it was early October.
And with respect to that, I think, I'm sorry, Madam, could you read back the question I had asked him, last question?
Can you describe that?
Can you describe,
before you were so
Previous
rudely
question.
interrupted.
Your previous question was, at that meeting, do you recall anything the colonel brought up of any significance? Answer, yes, he did. Yes, I did. Question, can you describe that? The colonel was very concerned about the way reports were being written within the agency, very concerned about it. And then Attorney Burke asked for it.
you said he was concerned with report writing. What about the reports were concerning him, to the best of your recollection from that meeting?
Some of them were incomplete. They lacked factors that would be contributing to probable cause. They editorialized different things.
When you say editorialize, what do you mean?
This is when an officer would give an opinion that was outside the scope of his investigation. Giving their opinion on something that really isn't facts of the case, or just making an opinion-based statement.
Perhaps something they weren't trained on at the academy as well. Would that fall into that purview?
Yeah, that would be it, yes.
And are you familiar with the term situation awareness message?
Yes, I am.
Is that something that came up at that meeting?
Yes, it did.
Can you describe what that is?
So there's 7 troops within the agency. Each part of the state is separated in what they call troops. Each troop at every shift has a troop commander that's in charge, a troop duty officer, excuse me. The term is troop duty officer. It's generally a lieutenant that's in charge of that troop for the shift that they're commanding. Generally, this happens, it's more important on the evening shifts and on the midnight shifts where the higher ranking officers generally aren't working. So anytime there's a significant event that takes place that the troop duty officer is responsible for putting out a situational awareness message. Now, that could be a trooper being hurt in a car crash, a cruiser crash, God forbid they're shot or stabbed. It could be a major car accident that's disrupting the flow of traffic. Could be any major event that's gonna be, that needs to be known.
Would something that would be potential media, I guess, attention, would that be something that would fall into that as well? Yes.
Yes, correct. Any kind of major incident that happened throughout the state, these would be sent out so that the colonel, myself, the division commanders could see it, and they would also, these messages would also come into EOPS as well.
You mentioned report writing. The colonel had concerns about report writing. Reports are written and then approved by somebody up the chain, correct?
Every single one of them, yes.
Okay. Did he have any concerns about that process?
Yes, he did.
And what concerns were those?
That seemed to be his major concern, that the supervision of the reports, the approval of the reports wasn't being done appropriately. The supervisor that approved the reports have to take the time to look, to make sure all the elements of the offense are in, they're grammatically correct, all the facts that need to be to support the probable cause are in the report.
Okay. And at that command staff meeting, do you recall one particular incident that might have stood out that was in the news?
Yes, I do.
And what was that?
There was a motor vehicle accident on Route 3 in Burlington where a woman had rear-ended a car. She appeared to be a little bit off. She was given a series of failed sobriety tests by the trooper. She passed them. She passed the tests. The trooper let her go. He had no other reason to keep her there or take her into custody. About 15 minutes later, she was involved in a second accident about 5 or 6 miles away, where it was a fatality was involved. We looked into the situation, and we had seen that we had arrested this woman in the past.
When you say we,
State police as an agency. We had arrested this woman in the past, a year or so earlier. We looked at the report that was written by the officer at the time, and it was lacking major elements of the offense. The descriptions that were provided it was just a very badly written report to support the arrest of the woman.
so if I'm hearing you correctly, that based on that report, that would have jeopardized the ability of the Commonwealth to prove beyond a reasonable doubt at trial for that particular incident.
Yes,
So that's a big concern.
very big.
Now, as a result of everything that you brought up about the report writing, capped off by that particular incident, what was put into place to address that going forward, to your knowledge?
At some point in time, as a result of that incident, 3 recruit training troops that had gone through the academy, the 81st, the 82nd, and the 83rd, were each brought back to the academy for a refresher course in OUI investigations, report writing, field sobriety exercises, so things to that effect.
And Trooper Sevier had testified that he believes that he was asked to participate in a training for OUI reports and OUI detection because of the incident that brought us here today. So you're saying that that's not the case?
Absolutely not.
I'm gonna object. The council appears to be testifying about what Trooper Sevier said a few days ago. I don't think that's an appropriate question for
Okay,
this witness.
okay, well, you're asking him to comment on the veracity of that testimony, but frankly, I get the point, and he'll ask 5 questions, and we'll get to where we are now, so I'm just gonna overrule the objection, but I understand it.
How many troopers attended that training?
Probably 600.
Now, if we could draw your attention to the incident that brings us here today, when were you first made aware that the young lady involved, Ali Bibo, was arrested?
I believe it was a Monday morning. Colonel was passing my office on the way to his office. He stuck his head in and asked me, in passing, "Are you aware of Valley Bebo being arrested?" He hit me about that, and I said, "I'm not."
Did he say Ali Bebo? I mean, when did you first hear her name come up? First time you heard her name?
Oh, I heard her name later in the day. At that point, he mentioned, have you heard anything about the arrest of a judge's daughter?
What about the incident, not the incident, the time you heard of her name first mentioned, where and when was that?
That was after a command staff meeting that had happened a little later that morning.
And what was the subject matter at that command staff meeting?
Again, during the command staff meetings, the colonel will ask if each division commander to go around the room, provide a briefing of what happened during the week. He got to Lieutenant Colonel Risting, who was a division commander of Division Field Services, the uniform division of the state police. During the meeting, he asked Colonel Risting if he was aware of a couple of different incidents. First one was that he asked him was, were you aware of a Lynn police officer being arrested over the weekend? Colonel Risting said no. Then he asked Colonel Risting, were you aware of a judge's daughter being arrested over the weekend or within the last few hours? Colonel Risting said no. Colonel Risting seemed a little bit upset that he wasn't aware of it. He should have been aware of it.
Why should he have been aware of those two incidents?
There is a policy in the state police that any kind of arrest involving a public official or to that effect should be reported through channels to the colonel's office, or to at least to the division commander. That did not happen.
Okay, so as a result of that command staff meeting, what, if anything, did you do next?
When the command staff meeting ended, I spoke to the colonel. I stayed in the office with him. Everyone else left. He had asked me, that's the first name I heard Bebo. And the reason I remember it is we have two lieutenants on the state police that were named Bebo, same last name. So it kind of rang a bell, no relation. So he asked me, have you heard about, did you hear about the arrest of Judge Bebo, the daughter of Judge Bebo? And I went, no. And he goes, can you get me those reports? And I think he was speaking, he wanted the Bebo arrest report, and I believe he wanted the Lynn police officer arrest report as well.
Is that fairly routine to come up in something like this?
Yes, he wanted to see what happened, read for himself what took place.
All right, so what did you do as a result of that conversation?
I left his office, I picked up the phone, I called Colonel Risting, I said the colonel wants the two reports. I had a conversation with Risting regarding the request. Risting stated that Sue Anderson was on vacation. She was a Troop C commander. He said, can it wait till she gets back? She'll be back tomorrow, I believe he said. Can it wait till tomorrow to get the arrest report? I said, yeah, it can wait. Didn't appear to be, the colonel didn't appear to be a big rush when he asked for it.
So then what happened?
The day went on, I went back to my regular duties. I found myself back in the colonel's office and briefing him on some matter.
How long after that conversation did you find yourself back in his office?
Probably a couple hours later, 2 or 3 hours later.
And then what happened then?
Colonel Risting came into the colonel's office. He had a manila envelope in his hand. And he said, here's the arrest reports. Provided the folder to me, and I handed them to the colonel.
So that's a chain of command thing?
Yes, he was the one that wanted them, and
All right, so then what happened after that?
that was the last I heard of it for a while.
So you gave him the envelope, walked out of the room, and went on with your duties, right? Is that what your testimony is?
Yes.
When's the next time, if you recall, that this came up?
I believe 2 or 3 days later.
And what was the context of that?
I would try to get into headquarters early. We have a gym there. I would try to get in early and work out. I had just finished my workout, and I got a phone call from Colonel McKeon.
What was the substance of that phone call?
The contents of the report, the Bebo report.
And what did Colonel McKeon say about the contents of the report?
And I'm going to paraphrase. Basically, he said he could not believe what he had just read, what he had read in the report. He was very concerned about the supervision on how the report ever became approved.
What about the report? What was your understanding of what he was upset about specifically, if anything?
Well, he told me, he said, he goes, the language that was used in this report that was put in, the language and the necessity of it wasn't needed.
And did he have any thoughts about how that was written in the report, other than what you just said? If you recall.
In its totality, I would say it was my opinion that he believed it was completely inappropriate.
And as a result of the conversation with the colonel, what did you do after that, if anything?
I did what he instructed me to do.
And what did he instruct you to do?
He advised me to get a hold of Lieutenant Colonel Risting and have the trooper come back into work and redact 2 sentences from the report.
And the 2 sentences that were redacted, you asked him to redact 2 sentences. What was the first sentence, if you recall?
I do. My father's a fucking judge. He's gonna kill me.
And the second sentence, you can paraphrase or generalize. What was the substance of that sentence? And was it in quotes?
Thank you. Basically, what was quoted was how Miss Bebo procured the method she used to obtain cash to procure heroin.
And was there any other directive that Colonel McKeon gave to you at that point?
He did.
What was that?
He advised that he wanted both officers given an observation report what took place. Meaning both officers, meaning the supervisory sergeant that approved the report and the trooper that wrote the report,
And who was the supervising sergeant?
Sergeant Conan.
And observation report, can you tell us what that is?
The observation report falls under the employee evaluation system. So we have a system called the EES system in the state police. And it's every year a trooper is provided with basically a review of their performance within that year, okay? What the EES observation reports are, they're used for the supervisor to make notations and give them to the officer when they see positive observations, if the officer does something well, or if they see something that isn't so positive, that may assist in providing the officer with some corrective criticism, really. They're put in a file, so at the end of the year, the supervisor can write the final EES report, the final evaluation. At that point in time, all observation reports are cleaned from the file. They last for 1 year. So it's really part of a system used for yearly evaluations.
Is it a disciplinary action?
Absolutely not.
And is there a way that you track disciplinary actions?
Yes, there is.
What's that?
Well, when I worked in internal affairs, a new system had been brought in because they needed to be able to track. As commanders come and go, a lot of times the officers stay on the department. So institutional knowledge can be lost as people leave. So they brought in a database called the Blue Team. So it's a way of tracking any kind of complaints that come into the department. And it's a mechanism that's used to bring the complaint or the misconduct or alleged misconduct forward into a system which is called IA Pro. So there's 2 databases, but they're connected. The IA Pro system basically keeps track of any kind of disciplinary issues that a trooper has, something that's actually disciplined.
So if someone's actually disciplined, that's where it goes, correct?
Yes, it can go from anywhere from discipline includes anything from a written reprimand all the way up to termination.
And again, the EES report, that's not a reprimand, it's more of an educational thing, right? Training, I think you said training.
Yes.
So after you ordered Colonel Risting to issue the observation report, what else, if anything, happened? Or what else, if anything, did you order Colonel Risting to do?
Just exactly. What I did do is I I ordered, and I said this on two occasions. I said, when the trooper comes in, make sure that he puts down on the top of the report the date in which he revised it, and that it is a revised report. I wanted that notably shown on the top of the report, so there'd be no question about that the report had been revised and when it had been revised.
Okay, so at some point you told Colonel Risting to instruct the trooper that wrote the report to revise the report.
Two channels,
That was you, it come through you.
twice, I mentioned.
So after you instructed Colonel Risting to do what you just said, did this come up again within the chain of command at any point, or was that the end of your involvement?
No, I received a call back a few hours later from Colonel Risting. He said, that's been all set, all taken care of.
And after that, anything else, or was that it? Did anything else occur?
That was the end of my involvement.
And back to observation reports. If someone feels they've been unjustly or inappropriately issued an observation report, what can they do about it?
First of all, the trooper doesn't have to sign. If they don't want to, they generally, it's provided to them by a supervisor, they look at it, they can acknowledge it by signing it, or they don't have to. But anything, if a trooper feels as though he received an inappropriate order or conflicting order, they have the right to appeal directly to the colonel that order. It's written in black and white in this department's rules and regulations.
Do you, off the top of your head, you know what regulation that is?
It's Article 5 point something.
So as far as, so you said appeal to the colonel.
Yes.
What if the colonel says, no, I issued an okay observation report?
So the way it works is the appeal is done through a representative of the colonel. He'll set up someone to conduct a hearing. A representative of his, generally it's a captain or a major, and they'll set up an appeals process. So they'll sit down, the trooper can come in, provide his side of the story, her side of the story, with counsel, if they deem it necessary, and lay it all out. Now, this hearing officer makes a decision basically based on the facts, as a representative of the colonel.
So this is so let me get this straight. If someone's issued a report, they don't agree with it, they appeal it to the colonel, and if the colonel says, no, this is appropriate, then you can subsequently go one more step over the colonel's head, is that right?
No, that's generally within the department, that's the last step. It's called the 43E hearing, 43E.
But is the colonel's not the final arbiter of the decision, somebody else is making the call on that, right, whether it was appropriate?
Yes, on his behalf, yes.
Okay. Now, are you familiar with the bail statute, 276, section 58?
I am.
Now, your experience as a trooper, have you been involved in when someone has to be bailed from the station?
Thousands of times, yes.
Can you briefly describe that process and any concerns about that process that you have as a trooper?
So it's all dependent on the situation, based on the situation and the party that's in custody.
So,
Every situation is different.
so when you arrest somebody, you have to contact a bail commissioner, right?
Yes.
So when you contact the bail commissioner, what's the conversation like usually?
Generally, the bail commissioner will ask you what the charges are, what their previous criminal history is, where they live, if they have any positive identification. A lot of times people don't. What the charge is, things to that effect. How many times they've been charged with the same offense? If there's a history of defaults.
Now, can you recall, to the best of your recollection, you've done some OUI bails, right? To the best of your recollection, OUI first offense, do you recall ever recommending a bail for an OUI first offense?
In my experience, I've never seen it.
And I believe that's all I have. I believe Attorney Burke might have some questions too.
Okay, thank you very much. I was gonna have her do the,
Whatever you want.
I was gonna have her do the cross-examination and then, yeah, what do you want
If
to
I
say?
will, I believe he's also responded Burke's witness as well, so.
Oh, is this one of your witnesses?
Well, if I get to go first, I'll say yes.
Do you want to do it first?
Sure.
Okay,
I
and
think
you have
we
no
all-
objection?
Thank you, no, none whatsoever.
Okay.
I think we all listed Mr. Hughes. I think we all listed Mr. Hughes as potential
Okay.
witnesses.
Also, I think I misspoke before when I indicated that all of the respondents were here. Major Anderson is not here.
She's doing by Zoom. She has family obligations.
Okay, yeah, I just wanted to clarify the record. Okay, thank you.
Reg, I said that kind of off the cuff. I indicate, it's a pretty loud sigh. I indicated that I was intending to, he was going to be a witness for the respondents.
Okay.
I will go in whatever order. I anticipate my questions were going to be more of a leading, but I can transpose them into direct. It's more what you're telling me my role is. If I'm
You're standing at the podium, why don't you start asking the questions? Okay.
Good morning, sir.
Morning, Mr. Burke.
At the time of your retirement, how many years had you been on the state police?
31 years.
And is there any type of case that you haven't had experience with?
No.
It began in 1986.
That's right.
Okay. And you talked about your experience with bail,
Yes,
talked about your experience with the EES system.
that's right.
Now, the individual who's given a EES system, in addition to their rights to appeal, they have the right to submit their own commentary about what they're being commented on, don't they?
Yes, I do.
So in this case, whatever the EES said about the arresting officer, he had the right to write whatever it is as a counterbalance, if you will, to what is said about his conduct, right?
Yes, and that would go in the file as well, for a year.
And so it's there for a year. In your EES system, as I understand it, you evaluate troopers and employees. You subject to the same thing?
Absolutely.
You have supervisors who have comments about your conduct?
I have, yes.
Probably won't get into that, but so you had
It
the
was
same.
generally good.
So you're subject to the same type of EES evaluation that every other of the 2,219 members of the state police is subject to.
Let me clarify that. You are up to the rank of captain.
Okay.
Okay.
All right. And when we talk about a paramilitary organization and chain of command, I mean, it goes without saying what it is, but what is a paramilitary organization?
An organization that basically mirrors itself on the United States military ranks and basically protocols, how things are done. It's very close. I served in the United States Marine Corps Reserve 7 years, and there's quite a bit of similarities between the state police and the Marine Corps.
Okay. And does the state police have court martials?
Yes, I do.
And military have court martials?
Yes, I do.
Have almost identical rules and regulations pertaining to the conduct of those court martials?
Yes, I do. Sergeant at arms and trial boards, yes.
Okay. Have you ever sat on a court martial?
I have, yes.
Imposed discipline when it's appropriate?
I have, yes.
And when we talk about discipline, you said that there's a range. The range of discipline, would you agree with me, goes from a written reprimand up to and including termination?
That's correct.
So could that also include a suspension from duty?
Yes, sir.
Okay, and are there lesser degrees between written reprimand and suspension?
Several. There's actually an appendix in the rules and regulations that spells out the class and type of offense in the different offenses, first offense, second offense, third offense. It's pretty much laid out, so there's it has a standardized process to it. It's not here or there, it's standardized.
All right, so is there something sort of like a presumptive sentencing guideline?
Yes, I'd say that's good equivalent, yes.
Okay, so if you're a repeat offender or if the event is more egregious than others, there's certain categories of discipline that coordinate with that?
Exactly.
All right, so was Mr. Sevier terminated?
No, sir, it wasn't.
Was he suspended?
No,
Was he docked any pay?
it was not.
Was he given a written reprimand?
No, it was not.
Okay, and he had the right to do his appeal if he chose to do so for the EES system, correct?
Yes,
Do you know whether or not there was a lawsuit brought within 3 weeks after this EES system report was submitted
yes, I do.
against my client, Major Anderson, and Colonel McKeon? Do you know whether or not that took place?
Yes, I do. United States District Court,
Federal court?
yes.
And you know the allegation was that he was disciplined by this EES system as one of his constitutional rights were violated?
I did read that in the complaint, yes.
Okay, do you know what happened to that complaint?
Yes, I know that a motion to dismiss the case was put forward to the federal judge, and based on the merits of the case was dismissed.
Okay, that was George O'Toole, right?
That's right.
Now, you, when Attorney Rasconi was asking you questions, you hesitated to state one of the sentences that Colonel McKeon wanted to have removed from the body of this police report, didn't you?
Yes, I did.
Why'd you do that?
Because the language in it is salacious and inappropriate.
Is it your opinion, based upon your 31 years of service, that the words, in quotes, "You have no idea how many dicks I sucked"?
Objection.
What's the objection?
I'm objecting to the salacious comment being repeated when we've gone to great lengths to prevent the record from having it.
Well, it's clearly in the record. You know, it's, yeah, you can have the question.
Can you repeat the question, Mr. Burke?
Sure. Based upon your experience as a member of this department, beginning from trooper to that of the second in command of the department, do you believe, based upon your experience, that it is appropriate to include in an arrest report for a first offense OUI the words, "She stated, quote, 'You have no idea how many dicks I sucked to get this for us,' end quote"? I think that's appropriate.
Absolutely, positively not.
And that was one of the sentences you didn't want to repeat, isn't it?
Yes, it is.
And Colonel McKeon have any response when he read that?
He couldn't believe that would be put on, something like that would be put in a report. Couldn't believe it.
What probable cause is?
Yes, I do.
Ever have to write any search warrants?
Hundreds.
Ever have to write any police reports for OUI?
Yes, I have.
Anything like that have any bearing on probable cause?
Absolutely not.
And when you had a chance to read this report,
I have.
probable cause is established in how many of the first paragraphs in this report?
Really, the first two.
Now, you didn't want any of that changed, did you?
No, sir.
Did anybody ask to have any of the charges reduced or diminished or impacted in any way that were brought against Ms. Bebo?
Absolutely not.
And did she, to your knowledge, do you know whether or not she admitted to sufficient facts to all the same charges that were brought against her?
Yes, sir, she did.
Did you or anybody at your behest do this or take this action because she was the daughter of a judge?
Absolutely not.
If I was a truck driver, a lawyer, or anybody else, would you have done the same thing in terms of revising this police report?
It's my opinion that the language in that was completely against the professional standards that we expect from our officers. That absolutely should not have been involved incorporated in that report at all. There was no need for it, absolutely no need for it.
Did you have a chance to read any of the statements made by conducted of the internal, by the Attorney General's office?
On my own.
Okay,
I did see part of Trooper Savio's, a portion of it.
okay. Now, you, when you were testifying, you said something about the effect of your requirement that you wanted to have put at the top the words revised with the date,
Yes, I did.
okay? And as I understand it, you spoke to whom?
Lieutenant Colonel Risting,
Okay, and he's in field services, right?
yes.
He's in charge of that.
That's
So
right.
we're going down the paramilitary structure of this organization, are we
Chain of
not?
command, yes.
Okay, so you spoke, the colonel spoke to you spoke to Colonel Risting, right?
That's right.
And then who's next in the chain of command?
It would be the troop commander, Major Anderson.
That's my client.
That's right.
And do you know whether or not there was any recording made of your instructions that was given to my client?
I do.
I approach him for a moment, George. Do you know whether or not Major Anderson made any notes of her conversation with Colonel Risting?
I believe at some point in time, I might have heard about that, but I'm not positive.
All right, well, let me hand you this document. You see where it's highlighted in the upper right-hand corner?
Yes, I do.
I'm going to assert to you that those are her handwritten notes. Can you read to into the record what that upper left-hand corner says?
On top of report revised, and it's underlined twice.
On top of report revised, right?
That's correct.
That's the instruction that you gave to Risting that Risting gave to my client, isn't it?
Yes, it is.
That was your idea, right?
Yes, it was.
And do you know if that was put into effect?
It was.
And were you interested in making sure that that was followed per your order?
That's why I asked Lieutenant, well, not asked, but that's why I told Lieutenant Colonel Risting twice to make sure it was done.
Okay.
I emphasized it.
Now, when this was done, it was done as a result of a direct order, correct?
That's right.
And just for, his honors and the commissioner's benefit, what's a direct order?
It's an instruction from a superior officer to follow a certain command.
Okay. Did Major Anderson have any option other than to obey that order?
No.
Is that a lawful order?
Yes, it was.
Did the Attorney General's office, as a conclusion of their investigation, determine that it was in fact a lawful order?
Yes, they did.
Would she have been disciplined had she not obeyed that order?
She would have been, yes.
Incidentally, how many women have been able to rise to the level and rank of major? Not trying to be critical here within the state police, but how many?
I believe 4 or 5 in the history of 150 years.
Have to be quite capable as a woman to achieve that rank, wouldn't you agree?
Yes, you do.
Did
As anyone, really, not just a woman, but anyone.
I wasn't disparaging the fact that you rose to that, but I'm just saying that's an accomplishment,
It
isn't
is,
it?
very much so.
And after Major Anderson gave that order, did anybody complain to you that she was inappropriate or lacked empathy in her handling of the affair?
No.
Anybody critical of her, say that she was overbearing?
No.
Had either the arresting officer or the reviewing officer for that police report been disciplined, would they have had the right to be given formal notice of charges?
That That's how the system works, yes.
Okay, so I asked you earlier and I kind of jumped off the topic. You have a court martial, right?
Right.
So if they were going to be disciplined for their conduct, do you have an obligation under due process to give them notice of the charges before you have a hearing on it?
Right, what happens is, there's an investigation, either at the troop level or through internal affairs. Once the investigation is done, it either sustains the charges or exonerates the party. If the charges are sustained, there's a disciplinary component to it, where they'll provide a waiver of discipline. So they'll say, okay, based on your actions on these dates, you'll forfeit 5 vacation days. You'll sign off, you'll give away 5 vacation days, that'll be your punishment. Now, the officer can sign off the waiver and take the punishment, or they have the right to go to a trial board and have a court martial.
Okay. And if they are convicted in a court martial, do they have the right of an appeal to the Civil Service Commission?
Yes, they do.
Do they have the right of appeal from the Civil Service Commission to the Superior Court?
Yes, they do.
Do they then have the right of an appeal from Civil Service to the Superior Court to the Appeals Court?
Yes,
And do they then have the potential for an appeal to the Supreme Judicial Court?
I believe they do.
Any of that take place with the arresting officer here?
No, because he wasn't disciplined.
Judge. Your Honor, you had mentioned something about 11:15.
Yes, I believe Ms. Duke is gonna get a call when.
They're going to text me in
They're
case
going
they're
to
running late.
All right, I just don't want to keep going if you're ahead of.
No, what I'll do, and I'll apologize, let me just, what I would do is, when she gets the call, I'll just interrupt you, apologize for interrupting you, or
You don't need
whoever's
to
being
apologize.
interrupted. So how much longer do you have to go?
About 5 minutes. Now, do you have any idea?
Can you hold on 1 second? There are sirens in the background, so I just wanted to wait for a moment.
And I was asking you about the arresting officer. Is the same true about the sergeant who did the review of this document? Was he ever charged with anything other than?
No.
Okay. Now, you had talked about the opioid crisis. Was this, you said that there had been a change. Would you agree that when you first came on in 1986, that there was, the attitude towards anybody who was using heroin was less than supportive from law enforcement?
Yes,
Just treated like junkies. Isn't that pretty much the attitude from everybody in law enforcement
I
back in?
wouldn't say everyone, but that was a common theme.
Okay, again, I'm not trying to be critical, but as law enforcement has evolved, has there been a change in circumstance and understanding of addictions?
I don't think there's anyone in this society right now that hasn't been touched by addiction at some point. Be it police officers themselves, we've had troopers that are friends of mine that become addicted, that end up serving time in prison. I have a good friend of mine that lost a daughter to addiction. This is across society. It's not a police public thing, it's just everywhere.
And when you talked about that there has been this new approach to individuals or an improved approach, was that part of your administration's attitude? Did you try to convey that through the members of the department?
Yes.
In charge?
Yes. And it wasn't only addiction, it also had to do with trafficking, human trafficking was the same. There was another change in the paradigm. People involved in sex trafficking, they've become more of a victim over the time too.
Just got a second. Almost finished.
Okay, you said, okay,
I
Skylar.
think in terms of order, I'm gonna follow. training change? Good morning. Mr. Hughes, I guess these days. correct?
Yes,
I'm Tom Kiley. I'm happy to meet you face to face.
you too, sir.
I represent District Attorney Early. District Attorney Early's name did not come up in your meeting with Colonel McKeon.
I have to apologize to you. The delegation from Uzbekistan is here.
My
We're gonna
best.
take you short. Must have known you were getting ready to cross-examine. So let me ask the parties what their preference is, because this may take a half an hour, it may take 40 minutes. Should we take like a real early lunch, or do you want me to just take a break and we'll come back in 30 or 40 minutes and then we'll go for a short while and then take the lunch break? It would seem we should just take an early lunch break so we can get everybody here out of here relatively early, but do you have a preference, Ms. Pruitt? No, Ms. Okay, none of the petitioners, so.
To you, Judge.
Okay, so why don't we just take the lunch break now and we'll come back in 45 or 50 minutes. Is that okay? And I apologize to you if it's inconvenience you, okay? I'm sorry, okay, so why don't we take an early lunch today and we'll come back in about 45 or 50 minutes, okay?
So
Okay.
12:15?
12:30?
You want 12:30?
Yeah, sure.
Okay, 12, she wants an hour lunch, so,
Thank you.
okay, so 12:30, we'll see everybody at 12:30. And
Thank you.
once again, Ms. Hughes, I apologize for any inconvenience. I have some questions from one of the commissioners, but I'm gonna hold off asking them because you folks might cover them in your examination. So, okay, Mr. Kiley, what do you have to, you're up.
Thank you, Your Honor.
Thank you.
I'm not going to reintroduce myself, Mr. Hughes. You indicated during your direct testimony that you were in the Marine Corps Reserves, correct?
Correct.
You attended boot camp, didn't you?
Harris, South Carolina, yes, I did.
And the academy where you worked has features similar to a boot camp, doesn't it?
Yes, very similar.
Physical training is very important during the academy. Occupies a significant part of the training time.
Every day.
Well, the course of the period at the academy, correct?
Yes,
And when you went through the academy, it was a 26-week training program.
yes,
It's still, and when the 81st and 82nd training groups, RTTs, is that what they're called?
yes, recruit training troops,
It was still 26 weeks, correct?
yes,
And the physical training took place every day
every day.
in the morning.
Yes,
Classroom work followed.
that's correct.
It was classroom work of some type in boot camp, correct?
Yes, it was.
Do you agree with me that language might be used in boot camp that might not be appropriate in a state police report?
Yes,
With respect to the training that occurred at the State Police Academy when you were, I don't remember what the phrase was that you used, when you were working there and I guess it was Captain Powers at the time, was Commandant.
yes, yes.
What was your position there at the time?
I was the number two, I was the executive officer.
Do you know who taught report writing when you were there?
I can't be positive, though.
Training changes over the course of time, doesn't it?
Drastically.
And a slide that might have been written by somebody when they were working in a municipal police department years before a training class might be outdated at some point, correct?
Yes,
Do you know Trooper Jamie Majarian?
I do know him, yes.
Was he teaching at the academy when you were at the academy?
No.
Had he taught there before?
In reference before,
Prior to your stint in the academy?
not that I know of, no.
Do you know whether he taught there afterwards?
Yes,
You know a trooper who taught at the academy named McKeon?
no.
Training continues, does it not, throughout one's career as a state police trooper or officer?
All the way through your career at every rank.
You know that Sergeant Conant was the supervisor to whom an EES was delivered, correct?
Yes,
Are you aware that Sergeant Conant had not undergone the training to be a supervisor as a sergeant at the time the report was presented to him?
I was unaware of that.
Were you aware that Sergeant Conant was a relatively new sergeant?
Yes,
Had been in the position for roughly 3 months in October of 2017?
that'd be fair to say.
Would it be fair to say that Trooper Sevier, that Trooper Sevier was a relatively new trooper in
Yes.
October 2017?
Correct.
In terms of the statutory structure that exists within the dealing with the paramilitary organization of which you were part, does the colonel have control or decision-making authority with respect to training?
Absolutely.
With respect to the testimony that you offered this morning, you talked about command staff meetings, correct?
Yes,
You talked about 2 different types, correct?
yes,
One is with a very large group of people, and the other is with a smaller, more compact group, correct?
yes,
The larger group appears quarterly, meets quarterly as a general proposition, correct?
or biannually, depending on the schedules.
Now, when the discussion came up at the large meeting that you described, you placed that sometime in early October, correct?
That's the best of my recollection.
Did it occur before the smaller command group meeting, at which Lieutenant Colonel Risting was asked whether he knew about the Lynn police officer and the arrest of the judge's daughter?
It did.
And is it the case that the concern about report writing had been a subject of discussion for many months prior to that large meeting?
It had been.
And the concern with respect to report writing was its professionalism,
Yes,
among other things.
yes.
Can you describe what those other things were?
Completeness, generally the who, what, where, when, and how should be included in a report if known. Elements of the offense should be included. And again, like I mentioned earlier, refraining from editorializing, giving opinions that have nothing to do with the matter at hand.
And with respect to those issues, you talked about something called situation awareness, correct?
Yes,
And is the acronym SAMS, S-A-M-S, a reference to situation awareness messages?
correct.
And the situations included, did they not, anything that might become public?
A significant event, yes.
And a significant event could, as you testified, involve the arrest of a political figure.
Would.
And I think you used the words or to that effect, correct?
Yes.
And the Lynn police officer, who was the subject of the first question to Lieutenant Colonel Risting, was not a political figure, correct?
No, not political.
But he was a law enforcement officer, and the thought was that it could generate some publicity, correct?
Right, he's a public figure.
And by virtue of that, there was something which the command staff understood was to be reported on a SAMS of some kind.
It should have been.
And the same would be true of the arrest of the judge's daughter, correct?
Yes.
Should have been reported on a SAMS, and it was not. So when the arrest of the judge's daughter came to your attention, I guess it would be on or about October 19th, is that the date? No, strike that. You placed the initial contact as on a Monday, correct? I think it is.
That's my memory, yes.
But it was, if I were to suggest it was what occurred on about October 17th, can we use that as a reference point?
Yeah, I can't be sure of the exact date.
I'm going to use that as a reference point. Assuming that was October 17th, the conversation that you had with the colonel at that point was short, correct?
The initial one, yes.
And the subsequent contact, is that when you were in the gym?
That was days later,
But that was when you were in the gym.
yes.
And was that conversation also brief?
Fairly brief.
The first conversation, the very first conversation, no more than a minute or two?
No, the colonel stuck his head in my office, asked me a quick question. I had no knowledge of it. I told him that and he moved on.
And certainly no mention of my client, district attorney, early in that conversation, correct?
No, I had no idea where it even took place. Could have been Cape Cod or the Berkshires. I had no idea.
And in the second conversation, when you were in the gym, I take it,
Just finishing up.
but still physically
Yes,
there.
yes.
So it comes by telephone, cell phone.
Yes,
And again, that's a brief conversation.
fairly brief.
No mention of my client Joe early in that
Not at all,
conversation.
no.
In fact, at no time in discussing, dealing with this matter prior to learning of the lawsuit that was referenced, Joe Early's name come up at all, correct?
Never did.
Was the language that you observed, I'm going to step back. There are all kinds of police reports, aren't there?
Yes, there are.
One size does not fit all, correct? There are supplemental reports written all the time, aren't there?
Yes.
And when you were in the investigative services unit, you updated police reports all the time, didn't you?
And it could be a recant, people recant statements that they had made, new evidence becomes available, things get updated constantly.
And in looking at a matter that might have involved an instance of potential human trafficking, that would be something that we might provide information to assistant district attorney or assistant AG that would not be public, correct?
No, anything that would lead to a further investigation, they would not make it public.
a phrase that I'd like clarified for me, because I don't necessarily understand all of the systems. There is something called, I think, an administrative journal, a daily administrative journal.
Yes,
What is it properly called?
that's, you have it correct, the DAJ, Daily Administrative Journal.
Is that a public document?
It can be, yes.
It isn't required to be, correct? Again, with respect to the acronyms, there is an acronym, I think, RAMS, R-A-M-S.
Yes.
Do you know what that stands for?
Report Management System, I don't know what the A stands for.
And what is it?
Depository of all the arrests that are done in the Division of Field Services. It's for Division of Field Services only. And basically, that's where it's a computer program where a record, a database record of, of the record of investigation is located.
Is the RAMS system itself public?
No.
In order for an item to go from the RAMS system into an application for a criminal complaint, does some action have to be taken?
Yes, it's part of the system. So when the arresting officer accesses the system, they'll write their report. It'll generate a complaint application and it'll be printed out.
A statement of facts is nevertheless required, correct?
Yes,
And people have an option whether to use a police report or write out a statement of facts, correct? Well, let me strike that. Prior to the adoption of the electronic filing system, effective in 2019, there was an option, correct?
I don't know that.
When is the last time you recall applying for a criminal complaint? If you don't have a recollection,
I can't be specific.
I think that answers my questions on acronyms. Again, I want to make sure I have this right. At no time were you made aware that District Attorney Early had an involvement in the decision-making process that led to the EES, correct?
No, contemporaneously with the events that were taking place.
And you've subsequently learned that there may have been something that went on from conversations.
That's correct.
Thank you.
At this point, is Attorney Bourgeois, there he is, Attorney Bourgeois, do you have any questions of this witness?
I just have one question I'd like to ask him, if I may.
Sure.
I want to make sure I understand the earlier testimony I heard. Is referring to a person, quote, as just a drug addict, end quote, is that consistent with the more modern or newer approach of the Massachusetts State Police to matters involving substance abuse?
No, it's not.
Thank you.
Okay, thank you. Are you going to be conducting it for?
Yeah.
Very good. Thank you. Then Ms. Perwick is going to be conducting the cross for the petitioner.
Afternoon. Now, how would you like me to refer to you? Lieutenant Colonel or?
Anything that's easiest for you, ma'am. Anything.
On direct examination, Candice Pruitt representing the petitioner. On direct examination by Mr. Risconi, you were asked some questions about the opioid crisis. Do you recall those questions?
I recall a series of questions, yes.
Sure. And he asked you some questions about how the state police was sort of changing their training and the way that they were dealing with people who were victims, if you will, of the opioid crisis. Do you recall those questions?
I do.
Now, the state police did not stop arresting individuals for heroin possession. Is that right?
They did not.
Okay. And the state police did not stop arresting individuals for operating motor vehicles under the influence of heroin. Isn't that right?
That's correct.
Because that's a public safety issue.
Absolutely.
Isn't that correct?
Yes, it is.
Now, you watched Ryan Sevier's testimony before this commission, is that correct?
Yes, ma'am, I did.
And you watched the entire testimony?
I might have missed parts of it, but for the most part, most of it.
Okay. You provided an interview to the Attorney General. Do you recall doing that?
Yes, I do.
And in that interview, you were represented by counsel, were you not?
Yes,
Tracy Minor was your counsel?
she was.
The interview was June 11th, 2018, is that right?
Sounds correct.
You reviewed that interview in preparation for your testimony today?
Yes, I've read it.
And you told the truth?
Absolutely.
When you were interviewed by the Attorney General, you didn't reference the opioid crisis, did you?
I don't believe I was asked.
Different question? Did you reference you did not reference the opioid crisis in your interview with the AG, did you?
I think he's answered the questions and he wasn't asked,
Yeah,
Judge.
well, he answers no, I would assume, because he wasn't asked.
No,
Thank you. And you didn't make any reference to any stigmas attached to individuals who were opioid addicted, did you?
I responded the same way.
In the same way as no, you did not.
No, I did not. I wasn't
Thank you.
asked.
Now, you said in your direct testimony that individuals who are, did you say political figures or
Public and political.
public and political? Were you referring to, and I don't want to get this wrong, special occurrences, SOC-05, is that what you were referring to?
You'd have to refresh my memory regarding the policy.
Sure. Does anyone need a copy of this?
I do.
Yes.
Alright, so why don't you take that?
I would like to.
I'm gonna have them pass them down to you.
All right, thank you.
You're welcome. And I'm gonna, may I approach?
Sure.
So I am showing you special considerations SOC 05. Do you see it?
I do.
And what does it say at the title? What's the title say?
Subject of the policy is special considerations,
And under that, what does it say?
elected officials.
And under that, what does it say?
It says notification.
All right, and after notification, what does it say?
The troop commander shall immediately notify the division commander and the officer of the superintendent when any elected or appointed official is arrested or detained for a crime.
Is that the policy that you were referring to earlier?
This is page 6 of 6. I'd have to see the rest of the policy. Do you have it available?
The policy that you just read now, did it say anything about the children of an elected or appointed official?
Not on the page you showed me.
Judge, for the sake of completeness, can we have the entire policy so that it can be put into context? as opposed to just.
Do you have the other 5 pages? Yeah, okay. Can you just furnish them to council?
When you were interviewed by the Attorney General, did you indicate to the Attorney General that elected or appointed officials, when they're arrested, that you should notify the division commander or the office or the office of the superintendent?
Again, I responded to questions put forth toward the Attorney General.
And so
the
your
answer is
answer to
no.
my question is no. Thank you. No trooper is required to follow an illegal order, is he? Was she? Simple yes or no?
No.
Thank you. Now, when you were interviewed by the Attorney General, you didn't report to the AG that following the meeting in Maynard, troops 81, 82, and 83 were sent for further training, did you? In fact, you were asked by the Attorney General.
I'm sorry, I didn't hear the answer.
I believe the answer was no.
No.
Okay, I'm sorry.
No, quite all right.
And in fact, you were asked by the Attorney General whether an action plan was developed as to who was going to do what about report writing after the meeting in Maynard. Isn't that correct?
I don't recall that.
If I may,
Judge, may I also get the 5 additional pages prior to going forward if they're available? I'd like to see them now as opposed to
Okay,
some future.
can I just ask, Ms. Pruitt, do you have the other 5 pages of that document you were referring to?
not with me, but we can have someone grab them.
Can we just have that done, so, and give it to council, please?
So that I can retrieve the other pages.
So Ms. Moran, you're getting that done, ma'am?
I'm trying, yes.
Okay, thank you. Okay, thank you.
All right, so I am going to show you your interview with the Attorney General. All right? Would you hold on to that?
Now, is this a document that's been introduced into evidence?
I think so.
Yes.
I think it's 38.
Exhibit 38, perhaps?
I just want to make sure the record is clear what you're handing them. So it's exhibit 38, Ms. Moran?
I think, yeah, I think so.
That's the way I listed it.
Yes, okay, so it's exhibit 38 that you've shown the trooper, which is his interview with the AG's office.
That's
Okay, thank you.
although, well, I will direct your attention to page 42. Starting at the top of that page. Do you see it?
I do.
All right. And why don't you read it to yourself?
You got that?
I got it.
All right. And so I'll just repeat my question. In your interview with the Attorney General regarding the meeting in Maynard, you did not tell the Attorney General that troops 81, 82, and 83 were sent for further training, did you?
I did not.
You didn't mention human trafficking in your AG interview, did you?
I did not.
How long was your initial contact with the colonel on October 17th?
5 seconds.
How long was your second contact with the colonel on October 17th?
You'd have to put that into a little more of a context. I was in a meeting with them, so it was hours. In context of what, ma'am?
In context of the arrest of the judge's daughter?
How long was that conversation?
Yes, the second one.
Well, the first part of it, I would say there was 2 parts. The first part was maybe a minute. And then after the meeting was ended, it's probably 2 or 3 minutes.
And what, if any, communications did you have with Lieutenant Colonel Risting?
Are we still talking about his instructions? Is that what you mean?
How many communications did you have with Colonel Risting regarding the arrest of the judge's daughter?
Again, during what period of time?
In October of 2017.
Probably quite a few.
What was the first one?
The first one was that the colonel wanted the police report.
How long was that communication?
I don't know, maybe 30 seconds.
What was the next one?
When Colonel Risting came in with the report, provided it to me, and I gave it to the colonel.
And how long was that?
2 seconds.
How many?
A few seconds.
What was the next communication with Colonel Risting? Lieutenant Colonel Risting.
Probably a couple of days later, when I spoke to him from the gym at the headquarters.
Was that October 19th?
That sounds fair. It was a few days later.
And how long was that communication?
2 to 3 minutes.
What was the next communication?
Well, he called me back and advised me that the order that I had provided him had been completed. That may have been a few hours later,
And how long was that communication?
a few minutes.
Did you have any communications with him after that regarding the arrest report of the judge's daughter?
I believe it was several weeks later after a public statement had been released by the department regarding the whole situation.
We're gonna go back. You first learned of the judge's daughter's arrest on October 17th, 2017, is that right?
Yes,
And you learned because Colonel McKeon asked you, had you heard about the arrest of a judge's daughter? Isn't that right?
yes, it is.
He didn't ask you if you'd heard about an arrest report containing so-called salacious information, did he?
Not in the initial one, no.
And then there was a command staff meeting also on October 17th, 2017, correct?
Yes, yes.
And at that meeting, Colonel McKeon asked Colonel Risting whether he had heard about the arrest of a judge's daughter. Isn't that right?
That is correct.
And then Colonel McKeon asked if Colonel Anderson had reported the arrest of the judge's daughter. Isn't that correct?
No, I think he asked Lieutenant Colonel Risting if he was aware of it, the judge's daughter.
So I'm going to ask you to turn to page 13 of your AG interview. I want you to start at line 21. Now, is this your statement? The colonel followed up by asking if Major Anderson had called him about or notified him about the judge's daughter or a judge's daughter being arrested over the weekend. Did I read that correctly?
Yes, you did.
Okay, and that's your statement, correct?
It is.
And at the command staff meeting, Colonel McKeon didn't ask if anyone had heard about a report with so-called salacious language, did he?
I don't believe he had the report at that time.
Well, now you anticipated my next question. At the time, your first conversation with Colonel McKeon and his statements at the command staff meeting, to your knowledge, he hadn't read the arrest report, had he?
That was my belief,
Right, because he asked you for a copy of the arrest report, did he not?
yes.
And after he asked you for a copy of the arrest report, you sent a text to Colonel Risting to obtain a copy of the arrest report, correct?
No, I believe I called him. I think there was a text message later. That's the best of my memory.
Oh, you called Colonel Risting?
So, yes.
Okay, how long did that call last?
Long enough to ask him to get a report for the colonel.
About how long?
Again, I don't know, maybe a minute.
Did you have the name of the arrestee at that point?
I did.
And then you also sent Colonel Risting a text?
I texted Colonel Risting weeks later about the incident.
Okay, so we're talking about on October 17th, 2017.
As of my memory is right now, I don't recall texting Colonel Risting on the 17th. No.
So we direct your attention to page 15 of your interview with the.
Ma'am, did you say 15 or 50?
15.
Thank you.
Starting at line 20. Question, okay, so then I think you said later on you send a text message to Colonel Risting. Yes. Did I read that correctly?
You did.
Colonel Risting then provided,
Objection, Judge. Are we confirming his testimony by introducing statements that are consistent with what he said here today?
I
I don't get the purpose
okay,
of
well,
my objection.
no, it's a, just ask your question, Ms. Brewer.
thank you.
Thank you.
So Colonel Risting provided a copy of the arrest report to Colonel McKeon, is that correct?
He did later that day.
And this is still October 17th?
Yes, it is.
And he provided a copy of the arrest report in your presence, is that right?
He did.
Because you all were in the colonel's office?
He did.
And you did not read the arrest report at that time, correct?
I did not.
2 days later, Colonel McKeon contacts you on October 19th at 9 a.m. thereabouts, correct?
Shortly before, yes.
Shortly before 9 a.m.?
Yes.
Around what time?
8:45.
And he called you with concern in his voice, I believe you told the AG, correct?
That's correct.
And in this conversation with him at or about 8:45 in the morning, he ordered revisions to the judge's daughter's arrest report. Isn't that correct?
Yes, it is.
And you didn't read the arrest report at that point either, correct?
I had not.
Now then, you relayed Colonel McKeon's order to Colonel Risting regarding the revisions to the arrest report, correct?
I did.
And you still hadn't read the arrest report when you relayed the
I had
orders. And then Colonel Risting reported back to you that he had completed your order. Is that correct?
Sometime later in the day.
We're still on October 17th,
Yes,
and you still hadn't read the report.
I had.
Now, Colonel McKeon ordered the revisions to the arrest report after the complaint had issued in the district court. Isn't that correct?
I didn't know that.
Let's talk a little bit about report writing. So you testified that there was a concern in the state police about report writing. Is that correct?
Several concerns, yes.
Several concerns. And you testified about we've talked about it a little bit, the command staff meeting in Maynard, Mass.
Topic came up there, yes.
You were present for that meeting?
Yes, I was.
And one example that was given of poor report writing was related to the fatal accident on Route 128. Is that right?
It was actually a report that had been written prior to that, involving the same party.
Involving the same party,
Yes,
who was involved in a subsequent accident that resulted in a fatality. Is that right?
right.
And the criticism about that arrest report was that there were only a couple of sentences in that arrest report. It didn't have enough information. Is that right?
Yes.
And then another example, and these are the examples that you gave to the Attorney General in your interview with the Attorney
Fair
General.
enough.
The other example was a report written by a lieutenant as to why a trooper should not have been arrested in New Hampshire, correct?
Yes, it is.
It's something that was outside this lieutenant's jurisdiction, is that right?
Not outside of jurisdiction. She was, according to policy, when an officer is arrested, they're required to notify their commanding officer, he or she. The commanding officer has to run this up the chain to let commanders know that the officer has been arrested or there's some kind of issue. So basically, it should be a report stating that trooper so-and-so was involved in some type of situation and was arrested by a certain police department.
I'm going to direct your attention to page 41 of your interview with the AG, starting at line 10.
Yes,
This is referring to Lieutenant Fletcher.
yes,
And this is your statement, this is your statement, right? She writes a report, and in the report, she decides to editorialize why this officer shouldn't have been charged and how the charges against him in New Hampshire were inappropriate, basically involving herself in interceding into another agency's investigation. Did I read that correctly?
you did, absolutely.
And in your interview with the AG, there was no discussion of examples of quoting an arrestee's statements as being poor report writing, was there?
Not specific quotes.
I'd like to have a moment, if I may.
Sure.
Thank you. Commissioner, I have no further questions at this time. We do have pages 1 through 5 on our computer screen. We sent our investigator to print it out, and we will provide it to the responses as soon as it comes.
Can I just ask you to remain at the podium for
sure.
a second, please? Because, as before, I've received some questions from one of our commissioners who's listening in on this and has some questions, and she relays that to Ms. Duca, who hands me the question. So I'm just reading you, the question, and then obviously, Ms. Pruitt, you can have an opportunity to ask follow-up questions as the respondents have that right. Once the order to redact was complied with by the trooper, what were the next steps for the revised report? What was the trooper to do, and what next?
The trooper was to bring the revised report to the court, provide the district attorney's office, a representative of the DA's office, a copy, the CPCS or the public defender's office with the copy, or make sure that the defense attorney received a copy, as well as a copy for the clerk's office, so it would go into the docket.
Okay. Second question. Have you ever issued an order to redact for in an OUI case?
I've spoken to troopers about their cases as a supervisor or sergeant and what they've wrote in their OUI reports. Yes, I have.
Okay. Has Colonel McKeon ever asked you to do a redaction?
No,
What's the difference between redaction versus revision?
redaction is removing a specific word, sentence, paragraph. Revision is a change in the substance of the report.
What was to happen to the original report submitted? Thank you.
It would stay in the file, the court file.
Okay. Are you aware of the Gilpin letter and her determination after inquiry that the language was appropriate?
Yes, I am.
Okay, and what is your response to that letter?
My response is, I believe Colonel Gilpin acted in accordance with political pressure. That's my response.
Okay. Okay, thank you. And last, have you ever had a case like this, similar with immediate attention generated by this case? Have you had prior cases like this?
Well, I was involved in the Boston bombing investigation.
Okay,
I was involved somewhat in the Aaron Hernandez case. But something like this, no, not to the level this I saw this. No.
okay. Okay, Ms. Pruitt, you're certainly free to ask any questions generated by those questions or any other questions you might have.
Actually, oh boy, I should left this with you. I am handing Lieutenant Colonel his interview again. I'm going to direct your attention to page 23 of your interview.
Is this a follow-up to the questions that I just asked
It
or
most
something
certainly
else? It
is.
makes no difference, frankly, just for,
It is definitely a follow-up to one.
okay, it makes no difference. I just want to make it as clear as possible. Thank you.
I believe one of the commissioner asked what was supposed to happen with the arrest report after Trooper Sevier revised it. And I'm going to direct your attention to page 23 of your interview, starting at the questions at line 15. And it starts with, as well as the court. What, if anything, is said about getting a copy of this revised report to the court? Is the assumption that you can just take it and bring it to the court and have it included in the court file? Your answer was, I think I was under the impression that the district attorney's office would provide that to the court as well as the clerk's office to go into, generally the reports go into the docket. So I'm assuming, it is my assumption and my belief that once the district attorney's office received that, this report would go into the docket. Did I read that correctly? Oh,
Not
sorry,
completely.
not completely, I will continue. Or
No is the answer.
or they would make a motion for it to go into the docket. Did I read that correctly?
You did.
That's all I have.
Thank you, ma'am.
I'll take this.
Okay,
That one with him so that he has a copy of Exhibit 38.
you just want him to have a copy of his statement?
No, I'm gonna ask.
Okay, well, I'll just give it, that's the exhibit. Okay, thank you. Ms. Rusconi, you have any questions?
I do, a couple. Attorney Kyle, can I have that for a second?
First of all, were you able to get the first 5 pages?
No, the regulations that I was looking at online were revised in 2009, and yet the copy that I made for Ms. Pruitt was revised, I think, in 2014. So I'll need to go back up to my office and print out the most revised copy, and I'm happy to do that.
Okay, I appreciate that.
Okay.
Thank you very
No
much.
problem. You're back.
Okay, Ms. Rusconi.
Your Honor, may I approach, I'm gonna hand Mr. Hughes a copy of the document we were just discussing.
Okay, sure.
Hang on to that for a second. Sure. Attorney Pruitt referenced special considerations for, it looks like at the top of the page is elected officials.
Yes,
Do you agree with me that they're not an elected official?
that's good.
And family members, they're not elected officials?
No.
Certainly not military personnel?
No.
You see where it says references at the bottom?
I do.
do you see any reference to the Division of Field Services policy of the Massachusetts State Police?
No,
And the special order regarding situational awareness messages, that's your understanding, that's where that comes from, right?
yes,
So a situational awareness message, again, as we discussed, is a situation that could generate publicity, and your testimony was something to the effect of a crash, a pursuit, a death, a trooper being shot, or in this case, a family member of the division, or a Lynn police officer, right?
right.
But as you read this, it doesn't appear that document, the Division of Field Services policy, is referenced in accordance with these considerations.
Not in this document.
And when you referred to, aside from Mr. Babode's report, you asked Colonel Risting to get the report of a Lynn police officer, right?
Yes,
You didn't say the name of the Lynn police officer, you just said Lynn police officer, right?
Right.
And the reason for that being is what?
Colonel brought it up in the meeting, so I figured he would want that too.
But as far as not using his name, just saying Lynn police officer, is there a reason one way or the other you would say Lynn police officer?
I don't believe he knew his name.
No further questions.
Gonna go, Tim, or shall I?
It seems to me, Mr. Burke, you might consider asking him questions on the other pages 1 through 5 in that document that we were speaking about. Yeah, that's what I was going to suggest. You want to take a 5-minute break, and then you can get the document. All the parties can review it if that's okay. Okay, why don't we take about a 5 or 10 minute break? Okay, thank you.
Thank you.
Thank you.
So you were asked questions, you were provided a single page policy that the state police have in place regarding special circumstances. Are you familiar with this?
Yes, I am.
You weren't given the entire policy, were you?
I was not.
Okay, and could you help us put this into context now that you have the entire document in front of you?
This document speaks to diplomatic immunity, civil infractions regarding diplomatic immunity, international driver's licenses, foreign nationals being arrested, mandated reporting, ship and aircraft incidents, death of foreign nationals, political asylum, elected officials, national senators and congressional representatives, as well as Massachusetts state senators and state representatives.
Okay, so when it's titled special considerations, that's not geared towards special considerations for a judge, is it?
No.
And this is public officials, elected public officials,
Right.
right? Like if a lieutenant governor, for instance, was operating at a high speed in early morning hours, you should know about that, wouldn't you?
Yes.
And with regards to, do you know where my client was on October 16th, 17th, and 18th?
I believe she was on vacation.
She didn't play any role in the decision-making that was, that occurred as far as your instructions to revise this report, did she?
Absolutely. Well, other than carrying out the order, no.
Okay, now, so you were interviewed by the Attorney General's office, right?
I was.
Anybody, so it's not just an Attorney General, there's a number of people there, right?
It was 3.
3 investigators, correct?
1 investigator and 2 assistant attorney generals.
One was a former assistant US attorney, wasn't he?
Yes, he was.
And older, experienced people?
Yes, I'd say so.
And did the tenor and the questioning that you were asked, does that follow the same script that the questions that you're being asked here, word for word?
Fairly close.
Okay. But will you ask the questions that I asked you today? Will you ask those questions by any of those people in the AG's office?
No.
So when you were referenced to page 42 or page 13 or page 15, and you were asked the question, well, you didn't say this. Were you even asked anything about those questions?
No,
Would you have answered any differently had you been asked those questions?
no,
Would you have given the same answer here that you would you have given the same answer there that you've given to us, the questions I've asked you or Mr. Visconti's asked you?
to the best of my memory, yes, absolutely.
Okay. Now, is there, you're asked a question whether or not a trooper is required to follow an illegal order, right?
Correct.
They're not, are they?
No.
You know who, you know the Gillespie case?
Very familiar with it, yes.
How are you familiar with that?
I was involved in it as a deputy superintendent. It came up through channels.
Okay? And tell us, Honor, about that case.
Trooper Gillespie was an E-board member for the State Police Association of
All right, so
Massachusetts,
you know the language when you say E-board. What are you talking about?
executive board member
For the union.
for the union. He was the Troop F, which is Logan Airport. He was the Troop F representative at Troop F. He had been, there was a standing order at Troop F that you couldn't park your car right outside the building.
Let me stop you there. Any problems with traffic over at Logan Airport?
It's a mess, it's a disaster.
Okay. Does that have anything to do with the order not to park your car out in front?
Not really, not in that location, no.
Okay.
It's, the reason that the order was given was so the public could come in, and if they had to come in and speak to a desk officer regarding a lost or stolen item or something to that effect, they'd have a place to park. So the troopers at the barracks were instructed, now at State Police Logan Airport, they drive their own vehicles to work. They were instructed not to park their vehicles outside in the public area where the public is to park when they come in to conduct business at the barracks. There was an ongoing hearing at the barracks regarding another officer parking outside the barracks. The lieutenant conducting the hearing saw Trooper Gillespie's vehicle parked right out front. He asked Trooper Gillespie to move his vehicle. Trooper Gillespie refused. Then the lieutenant said, well, I'm not asking anymore, I'm telling you, move your vehicle, it's an order. Again, Trooper Gillespie refused. He was charged with insubordination. He went to a trial board through the process, like I described
That's the
earlier.
court martial I talked about?
That's correct. Went through the process, he was found responsible for his actions, insubordination, and he was given a punishment. Now, exactly what the punishment was, I can't remember.
All right, I'm not interested in it. Okay, what was the substance of the insubordination charge? Was that failure to obey a direct order?
Yes, it was.
Did it go to a hearing? He had the right of appeal, right?
Yes, it did.
And the same thing with the arresting officer in Ms. Biabo's case? Had he chosen to do so, could have done something about not obeying a direct order or lawful order?
Can you rephrase your question? I don't think I
Let me
understood
answer
it.
this way. So was he went to civil service, Trooper Gillespie, correct?
Correct, yes.
All right. And did they come down with a ruling as far as the Civil Service Commission?
They did.
And what was that ruling?
They upheld the state police trial board decision.
That he was required to obey a direct order, correct?
Yes. I believe he went to the Department of Labor Relations with the two made a complaint there, and the same finding was found there.
Okay. Now, was there anything illegal about the order that you gave to Colonel Risting, who in turn gave it to my client?
No, the colonel has a statutory authority under Mass General Law 22C to do that. There was absolutely nothing illegal about it.
Would she have been disciplined had she failed to order it, obey that order?
She would have been.
Are you gonna offer that document into evidence? I'm
I
not
am.
suggesting you do, I'm just.
Sure. Now, can I have that back? Did you crinkle it up?
A little bit, sorry about that.
Okay, so this is, do you have any objection? No, okay, anybody?
No objection.
It's all 6 pages.
Pardon me?
It's all 6 pages.
Yeah, it says page, yes. Yeah, thank you,
Okay, thank you.
thank you.
Now,
Exhibit 39.
Just hold on one second, I'll have the court reporter. Do you need him to refer to that document again, Mr. Burke? No, thank you.
But
now, just so I understand the flow here, one of the commissioners asked you a question, I believe, regarding what happens to the original police report that had been impounded. I know you're not a clerk of courts or lawyer or judge, but do you know whether or not that stays impounded?
There's different type of impoundment orders. Generally, they have a date where they'll release it.
Okay,
So I don't know about how that worked out at the court.
all right. Whether or not there's other testimony or not, but can you just explain to those who may not be familiar with the criminal process? Once a person's arrested, the arrest report itself, the one, in this instance, the one that had those 2 or 3 sentences redacted out, is that put into use in some future court appearance?
Show cause hearing or something, maybe a motion to dismiss or something to that, yes.
Okay, how about well, you know what happened in Ms. Bebo's case, right?
Yes,
You know, she had what they call admitted to sufficient facts.
that's correct.
You familiar with that?
I am.
Okay, and does that require a reading of a portion or all of the police report so that the judge who hears that case has a better understanding of all the facts or allegations that were made and contained in that police report?
Yes, the judge and the defendant. And the defendant will be asked if it's accurate. Yes, it's read in open court.
Okay. And in this instance, would that have, if it had not been redacted, if those 2 or 3 sentences hadn't been removed from that, would that have been subject to public scrutiny during?
Objection.
What's your objection?
Cause for speculation. This witness has no first-hand knowledge.
It's only me.
Document.
I'm not, yes, go ahead. He can have a question.
You understand my question?
Yes, it would have been made public. It would have been an open court on the record.
And potentially read into the public record, right?
Yes, absolutely.
For any newspaper to pick up or TV station, anything, right?
Yes.
That seems fair, isn't it?
Objection.
Well, that's sustained.
Nothing fair about it at all, no.
You know,
Move to strike.
Yeah, that's, yeah, you didn't have to answer that, it's okay, so, okay.
Objections.
I'll ask it a different way, Judge, with the court's permission. There are very few copies of this original report, aren't there? Or weren't there?
It should have been.
And once it's impounded, it's actually a violation of the court order for anyone to release that into the public domain, isn't that true?
That is true.
That's a serious violation of the court's order, right?
Very serious, yes.
Okay. Do you know whether or not there's ever an investigation done to determine who or what entity it was that released that report into the public domain?
Not that I know. I don't believe there was ever an investigation, to my knowledge, no.
Okay. Now, a number of the commissioners had asked you, or a commissioner had asked you a question, whether or not you'd ever seen this much publicity. Had you?
Not Not to this, not in the manner in which this was made public, no.
Okay. Were you accused of criminal conduct?
I was.
Now, you also was asked a question whether or not you believe, or what you believe the reason was for Colonel Gilpin's letter. Was there a settlement at some juncture regarding this case?
Yes, it was.
Okay, did you participate in that?
No, I was dropped as a party to the lawsuit prior to the settlement.
So you could play no role in that, right?
No standing, sir, no.
Okay. Did you agree with the content of that letter that was submitted by Colonel Gilpin?
No, I did not.
And does she have supervisors or authorities who direct her conduct?
She does.
Okay, who would that be?
She reports directly to the Secretary of Public Safety.
All right. And you said there is public pressure. How do you know that?
I watched the numerous media interviews conducted by Trooper Sevio's attorney, Trooper Pullman. Saw Trooper Sevio's attorney on a PBS television show with Jim Browdy. It was in newspapers almost every day, internationally in newspapers around the world, this event.
Other than speaking to the Attorney General's office, ever had the opportunity to present your basis for what your conduct was?
Okay, thank you. Ms. Work, Ms. Kiley.
Thank you. Deputy Superintendent, when Ms. Pruitt started her examination of you, I called your attention to page 42 of Exhibit 38, correct?
Yes,
And she asked you a specific question about what appeared on page 42, correct?
she did.
With respect to that inquiry, the first inquiry, it related to whether at the command staff meeting, there was any kind of an action plan developed, correct?
Yes,
And your response was basically that the commanders were tasked with letting their, middle management, I guess would best say it, lieutenants and sergeants, to have them take more of an active role in overseeing the supervisor report authorizations and approvals. Is that your testimony?
it is.
Was that the plan that was developed?
Yes,
That question, I suggest about report writing. Do you have Exhibit 38 in front of you?
Exhibit 38 is right.
Yeah.
Here you go, sir.
I'd like you to go to page 42. And I'm going to ask you to read backwards, but not upside down. Are you at 42?
I am.
I would like you to go back and find the last previous question posed to you.
Okay,
Following me?
I believe I am.
I want you to go back to page 41 and so forth till you find the last question.
Are you on page 37, sir?
I think there's a question on page 38, line 9. But if you want to go
Okay,
back to
I see,
page,
yeah.
if you want to go back to page 37, we can go there too.
No.
This is a question that's being posed to you by that former US Attorney Peter Mullen, correct? And he's referring you back to what you had previously mentioned, which was, which related to the Maynard meeting, correct?
Yes, it is.
And he just asked you a general question, correct? Why don't you take us through these and tell us what you recall, correct?
Yes.
You went through what you recalled, and I want to direct your attention to the paragraph on page 39, begins with line 4.
Okay.
Do you see a reference to a SAM message there?
I do.
And in that paragraph, you indicate what the SAM system is all about, correct?
I do.
And I would like you to read into the record that paragraph. That paragraph that begins on page 39, line 4.
So if there is a troop that has 4 or 5 barracks in it, if something significant happens, the duty lieutenant is tasked with putting out a SAM message. It is supposed to describe the who, what, where, when, and why in an aborted form paragraph. I think that I meant to say abbreviated. But the pertinent facts are supposed to get out. That way, the colonel and myself, the division commanders, are aware of what's happening, things to improve. Maybe a cruiser crash that an officer was involved in, someone gets hurt, significant arrests, significant crashes, any kind of major incident that's going on to draw some kind of publicity, or that we may be question about later and need to know about.
Again, I think you misread that last sentence with a preposition. Significant arrests, significant crashes, any kind of major incident that's going to draw some kind of publicity, or that we may be questioned about later and need to know about, correct?
That's what it says, yes.
And that's what the SAMS program was about, correct?
That's correct.
And it was to let you know about situations that you might be asked about, correct?
Yeah, just like,
And publicity, correct?
yes.
Now, Ms. Pruitt then followed up with questions about the general order, correct?
She did.
And this is captioned special considerations, correct?
Do you want the witness to have that
Sure.
exhibit?
Yes.
Here you go, sir. Thank you.
Would make it easier. Thank you. Your document is labeled as special considerations, correct?
Yes, it is.
And when you look at it, it details instances in which the police officers need to be aware that there are specific laws and constitutional provisions that protect some people, correct?
Yes, that's correct.
And the only people that are listed in here that are state political figures are Massachusetts state senators and state representatives, correct? And that's on page 5 of 6.
Yes, sir, that's correct.
And there is a constitutional reference there, is there not, to provisions of the Massachusetts Constitution?
Yes, sir, there is.
And are you aware that there are constitutional provisions that deal with legislative immunity and the ability of the right of free passage that members of the representative body have, so that they can't be interfered with?
I am aware of it.
Special considerations that you were asked about do not control the SAMS process, do they?
No,
Nothing to do with it, do they?
generally not. No, it could incorporate it, but it does on a general basis, no.
No further questions.
Thank you. Mr. Bourgeois, sir, do you have any questions? Thank you. Thanks.
Just very brief follow-up on one of the questions from one of the commissioners. Mr. Hughes, you testified in response to one of the commissioner's questions that that what was supposed to happen, as you understood it, with the revised report was that it was supposed to go to the court. Is that correct?
Yes,
And I think you also said with a copy to the district attorney's office. Is that right?
yes.
Okay, in fact, there's been testimony in this case that what happened was the original report wound up going to my client, ADA Jeffrey Travers, and he took it to Mr. Keenan, who was the clerk of the court. Were you aware of that?
I am now, yes.
Okay.
The day
And
before.
my only question for you is, considering that the report, that you understood the report would go to the court, do you see anything irregular or inappropriate in my client bringing it to the court?
Absolutely not, no.
Thank you, sir. That's all.
Okay, thank you.
Add one more if you'll permit it.
I have one more going on.
Everybody has one more. So, should I hold you to one more?
Yes,
Okay, I will allow you, and
that'd be a long question.
then,
Attorney Tracy Minor, representing you, did not sit silent throughout your interview. She told you to answer the questions on multiple occasions, correct? And not to volunteer.
That's correct.
that's your one question, Ms. Rusconi?
Mr. Hughes, you referenced the investigation into what you referred to as the DeWolf incident, and that started around May of 2018.
The investigation,
The state police internal investigation into the incident where the woman killed the motorcyclist.
that sounds about right.
And at that time, when you spoke with the AG a month after the investigation started, you weren't aware that they were going to implement an OUI class for an enhanced training. You weren't aware of that at that point, were you?
No, when I spoke to Mr. Riley, no.
Okay, then. You're up. Take your time, yeah, just take your time. You want to consult with your colleagues, feel free to take whatever time you need.
Two questions.
Okay, I won't hold you to it, Ms. Pruitt.
The general order, is that exhibit 39?
Just gave it to Ms. Duca. Yeah, you want the exhibit 39, the general order?
Yes, please.
Okay, here you go, sir.
Lieutenant Colonel, exhibit 39 is a general order of the Department of the State Police applicable to the entire state police, correct?
Yes.
And I believe it's double-sided copy, referring back to the special considerations that I showed to you earlier. You could turn it over. It reads, the troop commander shall immediately notify the division commander and the office of the superintendent when any elected or appointed official is arrested or detained for a crime. Did I read that correctly?
That's what this policy says, yes.
Okay. And a judge is an appointed official, is that correct?
In my objection, if we're talking about the judge being arrested, it may have applicability. So I don't know what she's referencing this for.
I think she's gonna get to it. Yeah, thank you.
I'm sorry, could you repeat the question again?
Could you read the question back, please? Thank you so much.
And a judge is an appointed official, is that correct?
That's correct.
And a judge's daughter is not an elected or an appointed official, is that correct?
No, that she is not.
That's all I have.
Okay, thank you. Thank you, sir. Thank you. Hey, thank you very much. It was a long day. I appreciate your
Thank you.
Before
patience.
he goes, do we have any other questions from the commission?
No, thank you. Thank you, sir. Okay, what if anything is next?
Well, we would do Christopher Hodgins.
Okay.
I don't know that we'll finish him today. I would prefer not to have him come back later, but if we can try and go later, I'll try and get Chris.
We're gonna try to get him out of here if possible. If we have to go a little later, then so be it.
And I am going to be dealing with disputed exhibits 7, 18,
I could have any, do you swear to tell the truth, the whole truth, so help you God?
I do.
Okay, thank you, sir. You can have a seat.
7 twice.
Do you want some water?
Yeah, that'd be great, actually, thank you.
Thank you.
Appreciate it.
Here you go.
Thank you very much.
Sure. No problem.
I'm not getting up quite yet. I'm also going to be dealing with exhibit 12, exhibit 8, exhibit 11, and exhibit 13, and exhibit 14.
Remember, Mr. Kalu, we want to get out of here relatively early today.
Well, you know, I don't want this witness to have to come back.
I agree, okay.
And again, these are all disputed exhibits. The numbers that I gave.
Okay.
Afternoon, Mr. Hodgins.
Afternoon, Attorney Kiley.
Thank you for your patience.
Pleasure.
You know that I represent your boss, Joe Early.
I do.
We've come to know each other over the last several years,
Yes, we
correct?
have.
Would you please give us, the court, a view of your education as relevant to your,
Ms. Clay, you might just want to ask him to identify himself for the record.
I think that's Trooper Skivia. Please identify yourself for the record.
Christopher Hodgins, Hodgens.
Okay, thank you,
Thank you.
thank you.
Are you currently employed?
I am.
What is your current position?
I'm employed by the Commonwealth of Massachusetts, and I am an assistant district attorney in Worcester County.
Would you please provide the panel and the hearing officer with a brief description of your educational background as it pertains to your current position?
Sure. I graduated from law school in 1992, became a member of the Massachusetts Bar on December 15th, 1992. I joined the Worcester District Attorney's Office in January of 1995. I was hired by District Attorney John Conti. He hired me for the Appeals Division. I can continue from there on if you wish.
Well, your duties have changed over the course of time.
Correct.
You have certain general duties as an assistant district attorney.
Yes, my current position is I'm a Superior Court prosecutor. I entered that position in 2007 after District Attorney Early became the District Attorney. Prior to that, I was the Chief of the Appeals Division from 2002 to 2007. And in the Superior Court, I prosecute major felonies, including murders. But my other duties are actually with both district attorneys. I was an advisor. I am currently an advisor to District Attorney Early. I was also an advisor to District Attorney Conti. I am the chief of the Litigation Integrity Division, and I've held that position since 2018. My other duties have included under District Attorney Conti through District Attorney Early. I was the lead person for all public record matters in the District Attorney's Office. I was also, for a period, the enforcement officer for the open meeting law until that was taken back by the Attorney General's office through a change in legislation. I'm sure I'm missing something.
I'm sure you are. I'm sure you are. What did you start off doing in the district attorney's office?
Started off in the appeals division, representing the Commonwealth and all appeals to the appeals court, the Supreme Judicial Court, single justice of the appeals court, where I did about 100 appeals altogether. Thereafter, when I became chief of the appeals division, I supervised probably another 400 appeals, continued to do my own appeals. And then when I started trying cases in the Superior Court, prosecuted about 350 cases in the Superior Court, about 35 trials or so that have gone to a verdict. I've had a handful of district court cases too.
As the public record officer, when you were fulfilling that role, are you still fulfilling that role?
To a limited extent, again, there was a change in the law. There was a reform of the public record law a few years back, and it became much more burdensome, I guess, on the record custodian. So I wasn't unable to do it myself. We did actually hire somebody to do it.
Who is the person who is the public record officer, if there is one now?
Lindsay Corcoran.
Have you continued to work with Lindsay Corcoran on public record matters?
Yes, I continue to assist her in matters that require a legal eye. Lindsay's not an attorney. If it requires some legal attention, I'll take care of that.
And as the open meeting law enforcement officer, what did you do?
Oh, that was an interesting period. That was our role was to make sure that public bodies complied with the requirements of the open meeting law under the general laws. What that would require would be handling complaints by citizens who might claim a violation of some sort. My role would be to investigate the claim. If corrective action was needed, we would recommend that. We'd send a letter to the public body that was in violation and try to steer them in the right direction to straighten out whatever infraction was in place.
Have your special duties included any responsibilities with respect to the defense of actions brought against the officer or the district attorney?
Yes, I am also, and this is again under both district attorneys, if individuals in the office face litigation, civil litigation, if the office faced civil litigation, I would be the one designated to, at a minimum, monitor the litigation, perhaps hire outside counsel, organize that, hiring outside counsel, obtaining insurance coverage, or pursuing indemnity for the office or the individuals involved. Also monitoring other matters, including ethics issues, Board of Bar Overseers issues. We've even had other professional licensure organizations in Massachusetts that license our victim advocates. Have also been involved in monitoring those matters as well.
Those matters all still within your area of responsibility in your role as chief of the integrity, or the chief of the litigation integrity division?
Yes, and I should add this, the litigation integrity division was formally organized in 2018, but what it did is it brought together a number of functions that the office was already doing, and it brought them together into one division. The reason I say division is because it reports directly to the district attorney on all matters involving litigation in the office. The objective is to provide standards for our prosecutors and for police, to provide training to them, and to investigate compliance issues. And in designating me as chief of that division, the district attorney early gave me full power and authority to investigate any matter in the office that I deemed appropriate within the jurisdiction of that division.
Respect to training of prosecutors and police, is that a responsibility you had prior to the creation of the division?
Yes, in total, I've probably conducted, I would estimate, between 40 and 50 separate training matters during my career. And these would be to police, to prosecutors, presentations to the media, presentations to school officials on many different matters, from search and seizure to professional responsibility, special role of prosecutors, a whole variety of matters.
Step back from your duties for a moment to talk about relationships. What is the relationship that you have with my client, District Attorney Early?
I've known District Attorney Early since 2007. He was elected in 2006. I didn't meet him until 2007, I believe, late in the winter of 2007.
You socialize?
No.
What is your relationship to the respondent, Jeff Travers?
Jeff Travers, I knew as he was a prosecutor in District Attorney Conti's office. I think he left the office for a time. I didn't know him well. I just knew him as a prosecutor. He returned at some point. I don't recall if that was under District Attorney Conti or District Attorney Early. I knew him, but had no interaction with him till he became Senior First Assistant District Attorney, and then he became my boss,
Essentially, or he is your boss, he is a
He
supervisor.
is my boss, yes.
You have a direct report line to District Attorney Early, but you also interact or are under the supervision of Senior First Assistant Travers, correct?
That's correct, with that narrow exception that I had indicated. As Chief of the Litigation Integrity Division, I do report directly to District Attorney Early, because he did not want any interference with that. He wanted any problems in the office to be brought directly to him.
So, was there a particular impetus for the creation of that latter division?
I believe it was around the time, and again, as I said, a lot of the functions we were already doing, but I believe it was around the time that there was a lot of concern being raised about police conduct. And the district attorney wanted me to be on top of issues as far as any police misconduct that might affect our cases, that might have affected cases that have already been prosecuted. And he wanted to make sure that someone was keeping a close eye on those issues.
If I say Brady Giglio, does that mean anything to you?
It sure does.
What does it mean to you?
So those are cases, actually they're kind of, at least Brady, I think is 1963, Giglio's not that far after that, but those are US Supreme Court cases that put discovery obligations on prosecutors, special discovery obligations. And essentially, reading the cases together, we come pretty close to being open file discovery. We have a responsibility to make sure we are treating defendants fairly and that we aren't keeping secrets from them. And that if there is anything possible that is helpful to the defendant, we have an obligation to turn it over. It's a rigorous standard. It's one that we take very seriously. And it is one that District Attorney Early in particular has been very diligent about making sure that we comply with it.
Does Brady Giglio list mean anything to you?
Yes, some offices prepare what is referred to as a Brady list or a Brady Giglio list, and it's a list of officers who have done something they shouldn't have done. It's typically acts of dishonesty. It could be other things too, but they would then be put on a list. That list would be made available to the defense, and then it would be up to the defense to probe that further to find out why they're on the list, file a Rule 17 motion with the court to get into internal affairs records.
An internal observation report or EES cause somebody to go on a Brady Giglio list in Worcester. I asked you about relationships to his family, Travers and Early. Do you know Colonel McKeon?
I do know the colonel, I believe from District Attorney Conti's years, if I'm not mistaken. I believe he was in the detective unit at the time. I didn't have much interaction with him then. My interaction was with the commander of that unit at the time. That would have been Captain Tom Green. When District Attorney Early took over the office, I believe the colonel was promoted to the commander of that unit. Again, I had very little interaction with him because he typically interacted with the senior first assistant. That would be the point of contact for our office.
You don't socialize with him, do you?
No, I
Never have.
never have.
You know, the lady who would be sitting there, Susan Anderson, the other respondent to this matter.
I do not know her.
You know whether you've ever met her.
I don't believe I've ever met her.
There was a point in time, wasn't there, where Timothy Bebo was an assistant district attorney?
Yes.
Is he a colleague of yours?
Yes, again, under District Attorney Conti, I knew Tim Bebo at that time. He worked, might have been in the grand jury. I don't really remember exactly what his role was. I didn't have much interaction with him. I just knew him to say hi. That's all.
And with respect to his daughter, do you know her?
I knew her, yes. She worked in the district attorney's office under District Attorney Early for a short period of time.
Did you have interactions with her?
I had one conversation with her. I noticed she had a great facility with Spanish in dealing with people who came to the window. And I saw her in the copy room one day, and I just remarked that your Spanish skills are unbelievable. How did you learn it so well? And she told me she lived abroad for a period of time, and I picked it up. That was it.
I want to return to the issue of training. When was the earliest of the exercises in which you provided training to police or prosecutors?
Earliest date of training, it was pretty early on in my career. In the late 1990s, maybe. Could have been in the early 2000s, but it goes back quite a ways.
Has it been more or less a continuous function of your various positions?
Yes.
Have you conducted trainings with respect to the district attorney's policies on applications for complaints?
Yes, I have.
Was the earliest occasion on which that occurred one involving the media?
Yeah, there was a media presentation. It wasn't so much about applications for complaints. It was, I explained the background of that. What happened was when District Attorney Conti was the DA, he ran a very tight ship. He was very much by the book. And in fact, I remember in particular, there was a columnist from the Telegram, Diane Williamson, coined a great phrase about the office. She called it the legendary secrecy of the Worcester District Attorney's Office. And that's the environment that we operated in for many years, because District Attorney Conti was very cognizant of his responsibilities as a prosecutor, keeping certain information secret, essentially. When District Attorney Early became the district attorney, took office in 2007, he came into office with a pledge for greater transparency from the district attorney's office, and he delivered on that pledge by bringing in a staff of media people who we did not have previously, and he wanted to provide more information to the media about our cases. Like, there came a period where there was pushback from the media, there was frustration because they believed that the legendary secrecy of the district attorney's office was continuing, that we weren't providing enough information. And so the district attorney asked me to give a presentation to the media in order to explain to them why our hands are tied oftentimes with providing information, and that it's not so much the choice of the district attorney as it is a requirement under the law that we are not allowed to share a lot of information that we know the public wants to hear, but we either are prohibited from disclosing the information or we have to delay the disclosure of the information for certain times, such as trials.
We have exhibit 18, disputed exhibit 18, please. Second one. The witness have it. Disputed exhibit 18. Tell us what it is.
Yes, this is an email string. The first part of it, it's from Tim Connolly, dated Tuesday, May 13th, 2008. This is to me and some other prosecutors in the office, and CCing District Attorney Early and one of the first assistants. The subject is Media Day.
Thank you.
This is Tim Connolly, the communications director, had put together this Media Day scheduled for May 28th. And he was indicating the roles we would each play. He identified 5 of the prosecutors, and I was number 2, and it says Chris Hodgins, public records and rules of conduct, and in parentheses, 911 calls, Corey, what prosecutors can say, close parentheses. And I responded to this email, I responded on this email on May 23rd, 2008, Tim, you can count on me, it's a great idea. That's the first document. Then there's a second document. It's a single page document, and it says public record requests at the top. And then some text in there, and then there's a chart, and there are handwritten notes on this, and those are my handwritten notes. This was the outline of my presentation on that media day to members of the assembled media in the grand jury room in the courthouse.
Is there another page to it?
No, just I have 3 pages total, the emails and the text with the chart.
I think it's not really good. There's another page.
There is another page, I know there is a second page, I just don't have it here.
That's all that's in for providing.
Going top, I'm gonna approach, if I may. Sure.
Thank you. that document you're handing him, that's disputed exhibit 18, but with a fourth page.
It is,
That
and
was,
I'll ask him to explain.
Yep, this is identical to the first document, set of documents I was looking at, except it has an added page that says special obligations of prosecutors at the top. I can tell you that these 2 pages, public record requests and special obligations of prosecutors, I prepared this document. This was a handout. Oh, in fact, it has my name at the bottom. Office of District Attorney Joseph Pioli Jr., Assistant District Attorney Christopher P. Hodgins, that's on the bottom of both documents. And this was a front and back document that I created. So it was a single page handout. This was the front, public record requests, and the back was special obligations of prosecutors. And my handwritten notes are on these because I had saved this in a file after my presentation, and the handwritten notes, I believe I wrote the night before when I was preparing for the presentation.
Use that, strike that, I'm offering it, disputed exhibit 18. With the full 4 pages.
yeah, that's Ms. Pruitt.
No.
No,
No objection.
okay. Mr. Burke, I take it you have no objection.
I don't.
Okay, I think you have to give it to her.
Ms.
Ms. Fierro, just make sure she has all 4 pages.
Oh, do you have the first 3?
Yeah, he has the first 3.
Yes.
So,
This is exhibit 40.
okay, so this is exhibit 40.
Disputed 18 is now 40, thank you.
So things don't get confusing. Ms. Scully, can you just retrieve what you had given him, which is a copy of exhibit 40? Yeah, so yeah, so that way there's no confusion. Okay, thank you. Oh, thank you.
Have you used materials that are included in what is now exhibit 40 in other presentations?
Yes, this was done in 2008, I believe. And in 2014, I was asked to give a presentation regarding complaint applications. I believe I recycled this handout and used it in that presentation as well.
I have disputed exhibit 7, please. And I'm only going, first I'm going to be discussing particular portions from it. I'm not going to be moving in the cover letter that is writing by me. I'm going to be exploring pages 3748 and 3750.
Are you done with this document?
That's your copy, isn't it?
No, that's the exhibit.
It says it's exhibit 10.
You can stay
I
there.
am.
Okay, so I want you to send that to me. Thank you. I'll hand it to Ms. Duca. Thank you.
Excuse me, Mr. Kylie, do you only want those pages,
Well, here,
3748?
Out of that disputed exhibit, I will be using 3748 through 50, 3751 through 3755. And those, I think, should be given to this witness now.
Thank you. Ms. Scully, I'm just going to ask you, I'm just going to hand this to you to make sure it contains everything you're referring to,
Can I
okay?
use your table for a
Sure.
second?
Sure. Take your time.
answer.
Oh, it does, okay. Ms. Broder, do you know what he's referring to here?
I'm hoping he'll give us a base number so that we can
He's reading it.
This will be 3748 through 3755.
First, do you want to take a look at the document? You have it?
on the screen.
Thank you.
Thank you.
Thank you.
Attempted to, strike that. You identify what the materials that are in your hands.
Yes. These are there are 8 pages of materials.
The materials that relate to the 2014 session about which you just testified.
Yes, that's correct.
I'm going to offer the document.
Do you have an objection, Ms. Broder?
I'm not sure the witness has identified the documents. I believe his counsel identified the documents.
Okay, so why don't we just,
If he
why don't we
could-
start getting into it, and then I'll ask Ms. Pruitt again what her position is. Thank you.
Would you like me to go through each one? I can
Go
explain.
ahead.
Okay. The first document is an email from Lisa Ann Reich to Tim Connolly. She was the Academy Director of the Boylston Regional Police Academy in Boylston. And this was a request for someone from the DA's office to participate in a training on May 6, 2014. And then, in addition, there is the second page, which is titled Media Relations and On-Camera Training. And that was something that was hosted by the Lynn Police Department. And there is a third page that is related to that, media relations and on-camera training. It just discusses basically the media and police, their interaction. So these documents, these first 3 documents, or I know the first 2 documents, I'm not sure about the third, but the first 2 came to me from Tim Connolly, because these are my handwritten notes at the bottom, where I wrote on it May 6th, and I wrote May 13th, put a box around it, and then I wrote someone's cell phone number down. It might have been Lisa Ann Wright at the time. But this was the invitation for someone from our office to go to the Regional Police Academy in Boylston to discuss the issue of complaint applications.
And the materials that follow, would you please identify those?
The next document, the fourth document is, fourth and fifth document, it's typewritten notes. The title of it is Statement of Facts, Controlling the Flow of Information, Tuesday, May 13th, 2014.
Do you know who prepared those?
I prepared both of these documents. Second document, at the top, it says, why is there an opportunity here, question. There are handwritten notes on this document as well. These are my notes that I wrote the night before the presentation as I was getting ready to go to the Regional Police Academy the next day. Then the last.
There are then 2 more pages, correct?
Yep, there are 2 more pages, and this is the recycled handout that I was referring to before. I became a little more sophisticated with it. I added my business card at the bottom, and I also put a border around it to dress it up a little bit. Other than that, it's the identical document that I had used in 2008 for the media relations presentation. And the last document, and this was a handout that I presented to the police at the Regional Police Academy. And then the last document is an email from Chief Dennis Toole, Towle, and at the time he was the chief of police for Sutton. And I had saved this email because it was a complimentary email, which I'll be happy to read.
Oh, no, questions not been asked.
All right, but in any event, that's why I saved it and I put it in a file with all these other documents.
These are materials that you have saved relative to training that was conducted in 2018, correct? Or 2014.
2014, that's correct.
No objection.
No, thank you. There's a cell phone
Yeah, do you
number
mind
in
if I
there.
just redact that?
Oh, you, okay, so thank you. So she's gonna redact the cell phone number if
I'll redact it.
anyone has an objection. And that will be exhibit
Judge.
41, I believe. Okay,
Are we leaving in the complimentary part?
well, it's part of the record, Mr. Burke, so. Okay, Ms. Fiora, can you just do me a favor, once that's blacked out, just give it to the court
Absolutely.
reporter, and that'll be exhibit 41. Okay. Next.
You participated in this meeting in 2014, correct?
Yes, I did.
Did you use the materials that are before us as exhibit 41?
Yes, I did.
Did you address the question of probable cause statements in support of applications for complaints?
Yes.
What was did the materials that are before you reflect the policy of the office as it existed in 2014 with respect to applications for complaints?
Yes, they do.
Ms. Collins, can we just take a second so the court reporter can mark exhibit 41? Take your time. Do you need him to hold on to that, or can we,
I suspect he could do it from memory, but hold on, why don't you take it, Judge?
There
want
is-
me to take it? Okay.
With respect to the question you just asked, there is a typewritten statement in here in all caps that does answer the question. If you'd like me to read it.
Would you like to read it?
It says, never attach police narrative.
So we're talking about page 3752, correct? Who wrote that?
I wrote it.
Does the material here reflect the policy of the office
Yes, it
with
does.
respect to applications for complaint?
Yes, it does.
And there was a handwritten note after what you read to us, the never attached police narrative. Why, question mark, underlined? Do you see that?
Yes,
Who wrote that?
I wrote it.
Why?
I wrote that for my own purposes as I was giving the presentation to remind myself to explain to the officers why that was the case. The reason for it, and really the reason for my being there that day, is we were running into a situation where some police departments, they were applying for their complaint, they were applying for criminal complaints. Instead of just writing out a brief statement of facts, a short little paragraph hitting all the elements of the crime, what they were doing is they were taking the whole police report and they were attaching it to the complaint application. Problem with that is, once that gets filed in court and the complaint issues, all of those documents become a public record and we can't get them back. And so it was creating a problem for us because it was disseminating case material before the prosecutor had an opportunity to present the case in court. So it was jeopardizing the case because we're putting information out there It involves witness statements and so forth. It gives people an opportunity to change their statements if they should read about it in the paper or wherever. It could be putting witnesses at risk because they're identifying who the witnesses are. And it could be jeopardizing the defendant's right to a fair trial because the whole Commonwealth case is essentially being dropped into the public file inadvertently. So my purpose in going there is to encourage police departments, the police chiefs who were there, to encourage them to stop doing that and to only write a short and plain statement of probable cause that hits the elements of the crimes. File that in court. That ends up being the public record, and then the entirety of the police report remains completely confidential and is only in the possession of the police department and the district attorney's office. That's how it's supposed to work. And then through discovery, the defense gets a copy. And those would be the only three parties that have a copy.
That always gets a copy, correct?
That's correct. And that's how it's supposed to work. And it wasn't working that way, and that was the purpose of me going to that meeting of the chiefs to make sure we were all on the same page and doing it properly.
You have it on, there is additional handwriting on this page 3752.
Yeah.
Is it all yours?
Yes.
There is also a recommendation that is below the never attached police narrative with the same bold heading, right? Statement of facts with care. Correct?
Yes.
Is that was that the policy of the office at the time?
Yes.
There is a bullet that is demonstrate quality of investigation with brevity. Do you see that?
I do.
There's an arrow to the left on the sheet that has handwriting exceptions.
Yes.
Can you tell us about that, the exceptions?
Yes, this had to do with the question of brevity because I was encouraging all the chiefs to write probable cause statements that are only showing like maybe a quarter of a page. Short, very short paragraph. But I said there are exceptions. Sometimes you have to write more. And the exception I gave was one that was fresh on my mind. I wrote lobster case. That was a case that received a lot of publicity at the time out in Worcester County, where a lobster truck, trailer truck, had overturned on Route 395, and the lobsters were taken. And it was kind of a complex chain of events that resulted in this theft of a very valuable cargo. And because of the complex chain of events, I assisted the environmental police officer in preparing the statement of facts, and it ended up being maybe a page and a half or 2 pages long. So that was the exception, because we had to explain the different entities involved in the transportation and the theft and so forth. So there are exceptions to that, short little paragraph, and that was one of those exceptions. And I indicated a complex basis of liability. Oh, and I also indicated 2 pages, so it was a 2-page statement of facts.
Not required to remember all that far back, but there's also a line box around the word brevity. Is that your mark?
Yes.
And then there is a series of writings down the right-hand column.
Yes.
Is that your handwriting?
It is.
Is this a description of why you should be brief?
These are examples that I gave of how I would write the probable cause statement if I were the police officer applying for the complaint. So I gave the example of a breaking and entering in the nighttime. I just hit the bulleted points as examples of what you would write. And the next one was ABDW, assault and battery, dangerous weapon. And I did the same thing, just kind of hitting the main points that would hit the elements of the crime. And I indicated there's a small downside to being brief, and that is.
Yes, there is a downside. There's an upside to being brief. I think you've completed your answer.
Okay.
Proceeding down the page, there was another item that is emphasized in capital. It's the word timing,
Sorry, the word what?
timing.
Timing, yes.
Note on public access, not in dispute / only question of timing.
Yes, I see that.
Is that bold capitalization something you put on this sheet?
I did.
What is the question about timing?
What I wanted to emphasize to these police officers, and to the chiefs, I should say, is that we are not trying to suppress information from the public. I wanted to reassure them of that we are not trying to hide anything from the public. All our concern is the timing of when the information is released. So we just don't want it released when the case initiates with the complaint issuing from the court. We want the case, the facts of the case to unfold in court at a trial or at a plea or at a motion hearing. We don't want them coming out before we get to court. So that's why I was referring to timing. And if I could, I just noticed as I'm reading this, I wrote the phrase, defendant confessed to police. That was an important point.
It was an important point. Why?
Because typically we don't, what I told them is we don't put confessions in the statement of facts. You only put it in there if it is essential to a probable cause. So statements of the accused do not go in the statement of facts unless essential to probable cause. I emphasize that point. And that's not me saying that, that's the United States Supreme Court saying that.
You reiterated.
Yes, I wasn't making that up.
So following that page, there is another page that has your card down at the bottom. And it deals with public record requests, correct?
Yes,
That's something that is part of your teaching materials, correct?
yes,
And then the last page, I'm sorry, that 3754, it's not the last page, is again the special obligations of prosecutors, correct?
correct,
And it references, among other things, Rule 3.6, correct?
yes,
And that, again, that is something that you attached and taught at this to the chiefs of police at this training session.
that's correct.
8 years ago, I guess. So in your trainings from 2004 forward, have the special obligations of prosecutors, rules 3.6, 3.8, have they been a part of your training?
Yes.
And why is that?
I wanted to reassure the police officers, and let me explain why I'm reassuring them. In cases of unattended deaths, under General Laws, Chapter 38, Section 4, the district attorney's office is designated, the district attorney himself or herself is designated as the person to direct and control not only prosecution, but the investigation of the case. So in serious cases like that, where there has been a death, there is no question, the legislature has designated the district attorney to control the investigation. So it's at that point that the district attorney's kind of power or authority is at its zenith. So it's easy for us to say to the detective unit, state police detective unit attached to our office, it's easy to say, this is how things are going to be done. And they will carry out those orders because the district attorney is the person designated to issue those orders. The problem we run into is there is no similar statute for other crimes in dealing with local police. So the way we obtain compliance by local police is by persuasion. We explain to them why it benefits all of us to do to proceed in a certain way with complaint applications or other matters. And so that's why I was explaining to the chiefs sort of the rationale behind what we're trying to do. I was emphasizing to them, once again, we're not hiding information. We're not trying to conceal from the public the good work that the police are doing. But what we're trying to do is control the flow of information, the timing of information. And to emphasize that point, I pointed to rules 3.6 and 3.8 of our, it's a typo here, it says Mass Rules of Criminal Procedure. That's not correct. It's the Mass Rules of Professional Conduct. What's that?
You didn't type that then, did you?
I'm consistent but not perfect. I guess that was a typo. It says it correctly later. Mass Rules of Professional Conduct 3.8. It should be Mass Rules of Professional Conduct 3.6. And essentially the upshot of those rules is one rule, 3.6, deals with trial publicity generally for all lawyers. 3.8 deals specifically with the special responsibilities of prosecutors. And my point was to emphasize to the chiefs that even if court rules or your own training or your own customs lead you to do things a certain way, please don't necessarily follow that way. Follow the way that we are suggesting, because we have the greater responsibility. As lawyers, we have a greater responsibility. And 3.8 specifically puts that responsibility on prosecutors to take corrective action if the police do something that shouldn't have been done. So even if the police may have acted as they viewed it appropriately in filing the full police report in court, it's incumbent upon us as lawyers to take corrective action to make sure that filing doesn't deprive someone of their constitutional rights. That was the point I was making. So trying to lead them in the direction we want to go.
And the person whose constitutional rights would be interfered with is the defendant.
Correct.
The rules require one not to provide statements of the accused, correct?
Correct. And that's at a minimum. There are others involved too. There are privacy interests of people also mentioned in reports that we have an obligation to protect as well.
So let's talk about reports generally. There are all kinds of police reports, correct?
Correct.
And did your training involve other reports other than the statements of facts, the reports that might constitute statements of facts for the complaint application process?
Police reports are, they vary in what they're called, depending on the jurisdiction you're dealing with, depending on whatever computer program they have. Some will call them incident reports, some call them narrative reports, some call them summons reports, some call them police reports, some call them police narratives. They have all these different names, but it's essentially all the same. That's the police report. And that's the document that the police officer prepares that has the basic information about people, names, dates of birth, addresses, phone numbers, social security numbers, registration numbers, a booking photo. And then what follows is the narratives, where either one officer or multiple officers, it could be a half dozen or a dozen officers who all write narratives in connection with this report. And those will all be included as part of the police report. That's a police report. To be distinguished from what gets filed in court, what gets filed in court is a statement of facts or probable cause statement, also known as, that's attached to the complaint application. That's a different document than the police report. Very different document. And it's supposed to be a different document, at least as we view it in Worcester County.
It's a matter of policy in Worcester.
Exactly.
There's no requirement that policies be incorporated into a statute or regulation, is there?
Oh, I'm sorry, I didn't hear that.
Probably losing my
You
voice.
might be, yeah. I didn't hear you.
Policies. Policies don't have to be written, do they?
Policy is what comes from the mouth of the district attorney. It doesn't have to take any other form, as far as I'm concerned.
Why is that?
He's the one who sets the policy, the county. He's the one elected by the people.
Now you have that document in your hands. Go back a page. Don't go forward to your complimentary letter. Go backwards to the public records letter. Public records document. Yeah. Public records was a part of your responsibility in 2014, correct?
Yes,
Remained a part of your responsibility in 2015, correct?
yes,
You still have some responsibilities in that area now, correct?
I do.
So I also want out of Exhibit 7, pages 3741 to 3743.
Ms. Cully, can I just ask about how much longer you're going to be? I don't want to, curtail your time at all, but,
I don't know what time it is. I want to get him out of here today.
okay, well, you're controlling the,
I don't know what time it is.
so it's 3:10.
I'll finish by 4.
I know, but they have to go, so, and
I know.
is he done with that exhibit that he's just been
All of
referring?
those things are out of most of those things are out of Exhibit 7. And that is true. I have excluded what we had proposed, and included correspondence from me.
So what, are you going to ask that be admitted as part of already admitted
Offered separately.
separately?
So do you want to offer that again? Because there was an objection to the last one.
I want to have him identify this document. Could you please identify the document that is in your hands now?
This is a letter written by me to Colin Owyang, Owyang, Deputy Attorney General, Office of the Attorney General, right here, Ashburton Place, Boston, August 11th, 2015.
That's a year after your training in correct, after
Yes.
your training. What was Colin Oyang's position?
He was involved in enforcement of the public record law.
And were you writing this letter in your capacity as the public record officer?
Yes,
And what role does public record law, if you will, play in the policy that your office has concerning things like arrest narratives?
well, I guess put simply, if someone were to submit a public record request to us for a police report in a pending case, that request would be denied. And that has been the unbroken practice of our office since I've been there, for 27 years I've been there. For the reasons I had mentioned before, we do not want a police report out in circulation while a case is pending, because it can compromise the investigation, it can put witnesses at risk, and it can jeopardize the defendant's right to a fair trial. So if we do receive a request for a police report in a pending case, that request is denied. The requester has a right to appeal to the Secretary of the Commonwealth. The Secretary would then ask us for an explanation of why we're denying the request. We provide that explanation. If the Secretary is not satisfied with our explanation, the Secretary turns it over to the Attorney General's office for enforcement against the District Attorney's office. So that was the posture of this letter. There had been a public record request. It had been denied, went to the Secretary's office. The Secretary was not satisfied with our explanation, and it It was referred to Colin Aoyang for enforcement. Colin reached out to me, spoke with him on the phone, and I followed up with this letter explaining the position of the office.
And it relates to public records and dealing with matters that were of recent vintage or pending, correct?
I'm sorry, I didn't get that.
What does the substance of the letter relate to?
This involved two matters. One was the pending prosecution of Officer Michael Motika, and that we ultimately sent that to the Attorney General's office for prosecution. So that public record request kind of fell by the wayside because we no longer had the file. The second issue involved the pending investigation of the trooper Al-J. Savela murder. And in this case, we had taken the extraordinary step of providing a redacted copy of a state police report in a pending investigation. And the reason we did that was the murder happened in the 1950s. So the concerns that we had about compromising an investigation or putting witnesses at risk or jeopardizing a defendant's right to a fair trial had diminished substantially over that period of time, and we felt comfortable in the rarest of cases to provide a police report before the case got to the jury.
To change the ongoing policy of the office. That exception did not change the ongoing policy.
It did not. It did not, and it was a redacted report as well, so we felt comfortable sending it out.
Those are two specifics. On the next page, there was a reference to a database, correct?
You know what? It looks like there's a page missing. It says page 1 and page 3.
I'm gonna give you another copy. Three seven four one.
Yes, this has 3 pages.
3741 to 3743.
Does the petitioner have this?
It's part of the database, yes.
Okay, thank you.
It says 3741, 3742, 3743. And there is a reference on page 2 to the secure litigation management database.
This is a letter that you wrote, correct?
That's correct.
Relating to the items in this letter, correct?
Correct.
And I'm gonna offer the document. If I haven't already.
No objection.
No objection. Okay, could you hand the 3-page document, please, to the court reporter? Thank you, and that's,
Exhibit 42.
okay.
You have the document.
I
I have no question before you. Did Colin O. Yang in the Office of the Attorney General follow up with litigation relating to the matters in this letter?
Did Colin follow up?
Did the AG's office bring an action to enforce the public record law relating to the database?
Yes. Yes.
And what was the outcome on the searchable database?
Happened was only 3 district attorneys sought to defend our position. And that was that this secure litigation database that we have is not a public record. And only 3 DAs, I think it was Worcester.
Why don't you hold on one second?
Only-
Just hold on a second, sorry. Okay, sir, thank
It
you.
was Worcester, Essex, and Cape and the Islands. And what happened was the court, it ultimately went up to the Supreme Judicial Court, and the decision favored the position of the 3 district attorneys who essentially defended our position.
It's at some point following the 2015 documents that you say you were no longer the public records official, correct?
Correct,
And Lindsay Corcoran was, correct?
yes.
And a point in time came when Brad Patrician of the Telegram, I guess it's still the Telegram and Gazette, made a public record request for items involving impoundment and redactions filed by your office, correct, made by your office, correct?
Yes.
What can you tell us about that?
We did not have a file where we keep all of these documents. We maintain our files by case name. So it was not initially possible or feasible to pull together all the documents where we have filed motions to impound or redact. But we thought we could try to piece something together with the understanding that this was really a sampling of what we had and was not an accurate reflection of the entirety of what we have in our files. And the way we went about it is essentially polling individual prosecutors to see if they had any documents that were responsive to this request. We ended up coming up with 91 documents.
Had you have disputed Exhibit 8? That was what number?
This is Exhibit 42.
You can put that.
Thank you. Can I have that? Sure. Thanks. Thanks. Oh, sure, sorry. There you go.
I'm going to take this and take a piece of it out. Yeah, what I'm going to be excluding is material from me.
Attorney Kylie, are you removing your email to Peter Mullen?
I mean to.
Okay.
That's what I tried to explain inadequately to you last time.
I just ask a very brief question and I won't hold anybody to it. Attorney Burke, how much cross-examination are you going to do? Okay, none. Okay, none. Okay, I won't hold you to that. Mr. Bourgeois, you know, he's there. Okay, and Ms. Pruitt, and once again, it makes no difference what your answer is. I don't care how much time you'll take. In other words, you'll take as much time as you need and you will not be rushed. So I'm just your rough guess as to how long you would need to cross-examine this witness.
I think part of it depends on how much longer Attorney Kylie will be and how much he brings out additional on direct examination.
Okay, so, okay, thank you. Okay, what I'm gonna do now, just like, Mr. Bourgeois, how much time do you take to cross-examine?
If I had questions, sir, there would not be more than 2 or 3.
Okay, 2 or 3 minutes.
2 or 3 minutes.
Okay, I'm just gonna take a very brief break now. And Ms. Kylie, you know, what time we get out of here is really dependent on you. I realize it's your witness. You take as much time as you want, but at some time, we're gonna end it. And if he has to come back, I apologize to him and you.
I'm going to try and finish. I understood we're going at 5:15, and if we can get it finished before, if a little bit later, I intend to try and stay in order to finish this whole case.
Okay, so you're gonna try to speed it up? Okay, we can, okay, at this point, I'm just gonna take like a 5-minute break. What?
I wasn't quite sure. You're expecting to go to 5:15?
No,
I hope not.
you're on page 9 of a 10-page
That's what I
outline,
heard
right?
too.
He's on page 9 of a 10-page outline.
What's that?
I have an outline on occasion.
Okay.
He's on
Okay.
page 9,
I'm
it's
on
10
page
pages
9.
total.
He's on page 9 of 10?
Yeah.
Okay, good.
But
Well,
I'm not making any promises.
we're gonna take just a very short 5-minute break. I've been asked to take a short break. We'll take 5 minutes, if that's okay.
I'm dealing with public records.
I know.
Document that is before you, the letter to Colin O'Yea has not been admitted, I offer it.
I believe I gave that to the commissioner. This is the 2-page one that was unmarked.
Colin O'Yea,
Right, but it was,
is that admitted?
Yes.
What exhibit number is that, please?
The Colin O'Yea
Yes.
letter is exhibit 42.
At some point, a public record request was received from
What's the problem? No, I didn't.
we were talking about a letter that was received from Brad Patrician after Ms. Corcoran had been designated as a public record officer, correct?
yes,
And you reviewed that letter, did you not?
I did.
And you reviewed as well the materials that were provided to Mr. Patrician, correct?
I reviewed them and categorized them to an extent.
So, the documents produced to Mr. Patrician are disputed exhibits 10 and 11.
This is 10.
I'm probably gonna move them in together, a single exhibit.
It's 11.
You identify the materials in exhibit 10 and 11 in terms of generally what they are.
The first two documents, that's the letter to Brad Patrician, Worcester Telegram and Gazette dated February 20th, 2017, signed by Lindsay Corcoran, Records Access Officer. I reviewed this letter before it went out. I reviewed the attached documents, and without looking at each document, this generally appears to be the package of material 91 documents that went out. Redacted documents that went out.
You offer the documents.
Do you have an, you're offering,
One is one exhibit.
it's one, okay, from, okay, the disputed exhibit 10.
No objection.
Okay, thank you.
To 10 and 11.
So 10 and 11
But the whole package came in two parts,
as exhibit 43.
correct?
Oh, so you want exhibit 43, formally disputed exhibit 10 and 11?
Yeah, they were, that is, the package went in two parts.
Okay, so it's just, okay, so it's, okay.
I'm sorry, did the witness identify the second batch of documents? No? So if the witness could identify the second batch
Yeah,
of
why
documents.
don't we just do it piecemeal? So disputed number 10, you want, that's a record request from the newspaper. Petition has no objection, so that'll be exhibit, what, 43? And just have him identify number 11.
It includes response.
Yeah, just have him identify what 11 is.
What does that mean?
Please
It's gonna go
identify,
through
please
Each one of the
identify,
documents, 91 documents.
please identify the document again.
What's 11?
The top one is the one that has the cover.
Okay, so 3844 through 3967. It's just clipped together. This is it starts with the 2-page cover letter to Brad Patrician, as I had said before.
Which,
He testified to this
Okay.
already.
yes, and I believe, may I inquire further?
Sure.
What's the next package begin
And the
with?
next package is 3968 to 4040.
And what, as you've done through it, what does it appear to be?
This next package appears to be documents that were filed in court, Fitchburg District Court, Worcester District Court, Fitchburg. These are various courts, various docket numbers, all filed by assistant DAs in the Worcester County District Attorney's Office.
Are they among the 91 examples provided to Mr. Patrician?
Yes, there are,
I offer the documents,
Okay, so you're offering both packages.
all packages as one exhibit.
It's one exhibit. Okay, no, Ms. Pruitt. Ms. Pruitt, do you have any objection?
Can we see,
Oh,
can we see
sure.
the document?
Thought we all had notebooks.
So, can you just give them back to me, please? Okay, thank you. Thank you. And can you put a clip on this, please? And can you go to show them to Ms. Pruitt?
Thank you.
Take your time reviewing them.
No objection, thank you.
Okay, so have you had
Thank you
enough
for-
time to review that, Ms. Pruitt?
We've seen those documents
Okay, very
before,
good.
thank you.
I realize it's late. I don't wanna rush anybody. I wanna make sure everybody has enough time to do what they need to do, okay? So no one's rushed here. Thank you. Here you go, sir. And I'd ask you to give that to the, that's everything? Did you combine everything?
I combined them into one
Okay, so,
packet.
okay, so that's exhibit 43, I believe.
Yes.
Okay, so let's just give the court reporter a second. Okay, thank you. Okay, Ms. Skyler.
Testified before we put in this exhibit 43 that you categorized materials to a certain extent, correct?
correct.
Tell us what you did.
So of the 91 motions to impound or redact, by my count, there were 39 that pertain to prejudice to the defense, risk of prejudicial pretrial publicity, or the right to a fair trial.
Thank you.
There were also I think I may have gotten this back. No, I apologize. It was, of the 91, there were 73 that pertained to that. And there were 39 motions to impound or redact that pertain to documents filed in connection with applications for criminal complaints.
Thank you. Was that an exhaustive list?
No, not at all.
How often are documents impounded? Is it a frequent occasion, instance in Worcester County?
Absolutely. I filed a motion 2 weeks ago.
About redactions? Are they a common occurrence?
Redactions are more common now, I think, than they used to be.
Why is that?
My memory is there was a change in the rules that encouraged redaction over impoundment. Because, and I think the philosophy being impoundment would take a document completely out of public view, where redaction would enable the public to see the document, but just eliminate those portions that might be problematic.
You've listened to some parts of this proceeding, have you not?
I have
Watched them?
a little bit, yeah.
Have you read them on?
Yes, not as much as I would have liked to. I was a little bit busy, but I did see a little bit. And I read a couple of newspaper articles about it as well.
With respect to the dates, if we accept October 17th of 2017 as the date the matter was filed, were there materials that you were discussing prior to that date, proximate to that date, that dealt with issues concerning pretrial investigations, period?
Yes,
I have disputed exhibit 12. Can you identify what has been handed to you as disputed exhibit 12?
two letters. The first is to, both letters written by me. First is dated October 16th, 2017, and it's to Jonathan Sklarzik, SCLARSIC, Assistant Attorney General, Office of the Attorney General, here at Ashburton Place. This is regarding Trooper L.J. Savela murder investigation.
Can you stop there for a minute? Have we seen a reference to that in one of the documents that you previously identified?
Yes.
Go ahead, please.
This is a 6-page document, single-spaced. The only difference from the original is this one is on both sides. I always write letters on only one side of the paper, so that's the only difference from the original. And same second letter is a 2-page letter, also dated, same date, October 16th, 2017. This one is to Rebecca Murray, Supervisor of Records, Office of the Secretary for Commonwealth, McCormick Building, 1 Ashburton Place. And this is regarding public record request of Aaron Hernandez. This is a 2-page document. I CC George J. Leontire, Leontire, Esquire, and Mr. Todd Wallach of the Boston Globe.
Oh, George Leontire was? Or is?
I believe he was a lawyer representing the family of Aaron Hernandez, if my memory is correct.
Did you discuss the issues that are laid out in these letters with District Attorney Early prior to or on October 16th, 1997?
Yes, discussed them extensively.
I'm going to offer the documents.
Petitioner?
No objection.
Okay, thank you. That would be 44. Okay, that's exhibit 44.
What?
Wait, hold on a second. Watermark.
What were the issues of concern with respect to the public disclosure of these materials, if any? expressed in these letters?
The Trooper L.J. Savela investigation, again, this had to do with public disclosure of reports we had in our possession. We were continuing to oppose producing material that was sought by the requester, and this went through the appellate process. It went to the Secretary's office, and then it went to the Attorney General's office. And this is my letter to the Attorney General's office explaining our position. And I can point to exactly part of it. On page 3 at the top, this is kind of the heart of the letter, where it says, as a general rule, this office does not make public disclosures of matters that are under investigation or pending in court. Given the age of the instant case, however, we reviewed the investigative report to determine if it represents an exceptional situation where some information may be provided to the public without compromising the investigation or potentially prejudicing the prosecution. As a result of that review, the office made public a redacted state police report. Such a disclosure of a matter under investigation is extremely rare.
The letters are both dated October 16th, 2017, correct?
Correct.
Is that approximate to when you had a discussion with District Attorney Early?
The October 16th date is the exact date that I mailed it, because I always mail letters on the day that I put the date on it, and I mail them personally. I would have put it in the box on that date. I believe it would be unlikely I spoke to the district attorney on that date because there were 2 letters and there was a lot of material. It's possible I spoke to him on that date, but more likely I spoke to him at the end of the prior week. And on the second letter, to answer your question, the second letter, the issue there was Aaron Hernandez was a famous figure, played for the New England Patriots, and unfortunately he died in custody in an institution that was in jurisdiction of Worcester County, and there was a significant media interest in his death and circumstances surrounding it. In particular, there were some notes that were left behind, and the media very much wanted to get its hands on the notes that he left behind, and we were refusing to disclose those. And the heart of this this letter, let's see, I believe there's another letter that followed up this. This was kind of the initial a letter that preceded it. But what we were doing is we were invoking the privacy exemption under the public record law, General Laws, Chapter 4, Section 726, C, privacy exemption. That's what we were invoking because we did not want to make public the final thoughts of Aaron Hernandez. We believed that that was for the family, and if the family wanted to make it public, it was up to them. We're trying to protect his interests.
On how many other occasions have you deviated, in your experience as public records officer, deviated from a policy on release of investigative materials?
Deviated from the policy?
Let me say, accepted and provided an exception.
I don't think we've ever deviated from the policy. I think we've just taken a reasonable look at it. And in the case of the L.J. Savela case, we came to the conclusion that after 50 years, the likelihood of prejudice was low, so we could release some portions of the report. In the Aaron Hernandez case, we didn't yield at all, and we never divulged any information with respect to his death.
And
Except for I think the reports we released redacted copies of the reports of the institution and so forth.
Prior to your involvement with the integrity division, litigation integrity division, in terms of communications on the professional rules, was that done by somebody else within the office?
Communication to,
May I have disputed exhibit 18, please?
Are you
I'm
done
sorry,
with
21.
21? Are you done with these two?
I'm not going to inquire further with respect to that.
Okay. Can I just have it? Thank you.
To identify the document that has been handed to you.
yes, this is an email dated January 12th, 2016, from Jeff Travers, CCing Joseph Early. And it went to all staff ADAs, Worcester County. It's referencing Mass Rule Professional Conduct 3.8. District Attorney would like to bring to your attention the new ethical rules for prosecutors effective in April. It is imperative that you take time to review these rules. And there are 1, 2, 3 pages attached.
Did you receive it?
I did.
Was it Senior First Assistant Travers' role in the office to deal with the rules of professional conduct prior to your taking over the litigation, the integrity division?
I don't think we were ever exclusively responsible. I think it was, we kind of had overlapping responsibilities.
Between you and Senior First Assistant Travers?
Yes, I think that's fair to say.
Was there ever a time when rules of professional conduct, and in particular the provisions of Rule 3.6 and Rules 3.6 and 3.8, were not on the minds of the leadership of the DA's office?
Never. It was on the minds of leadership under both administrations.
Well, after strike that, you were not a participant or recipient witness to communications about the judge's daughter matter as it was happening, correct?
That's correct.
You're not here as a recipient witness, so to speak.
I didn't know about it until I saw it on the internet.
You're here to talk about the policies and practices of the office, correct?
Yes.
After the overblown publicity, if I may call it that, were you involved in seeking to further the policy objectives of your office on a broader basis?
Yes.
May I have disputed exhibit 14, please?
Are you moving this? Are you going to move that this
I thought I
meeting?
did. I move it. Thank you.
Thank you. Ms. Prower?
No objection.
Okay, thank you.
Exhibit 45.
That's exhibit 45. Thank you.
I have a document before you. Can you identify it?
Yes, this is a letter on the letterhead of the Massachusetts District Attorneys Association. It's dated January 15th, 2020. It's addressed to Secretary Thomas Turco, Executive Office of Public Safety, 1 Ashburn Place, Boston, regarding uniform complaint application procedure. It's signed by Anthony Gallooni, Hamden District Attorney, MDAA President. It's a 3-page document. Well, it's 2 pages, but 1 page is front and back, so 3 text.
You recognize the contents of the letter.
I do.
What do you recognize them to be?
The overall content of the letter is something that I discussed with and helped compose with District Attorney Early.
Who offered the document?
We'll object to that document.
Okay, what's the basis of the object?
He didn't draft the document, he's not the recipient of the document's not to him. The document was 3 years, nearly 3 years after the incident that gave rise to the order to show cause should not be admitted.
Okay, well, that's a fair objection, but given what I've done throughout, I'm going to admit it.
Exhibit 46.
I have no further questions at this time.
Why don't you just stay there for a minute, okay? Because there's some questions from one of the commissioners. So, you know, as some of my fellow commissioners are listening to this via Zoom and they submit questions, so I'm going to ask you the question as was given to Ms. Duca, who gave it to me. Did District Attorney Early ever ask you in your capacity as Chief of the Integrity Unit as to the possibility of a conflict of interest as to Judge Bebold or his daughter and how he or the office should proceed during the week of October 17 through 2017 as to Ms. Bebold?
No, he did not.
No.
I would add that I was not the chief of the division during that period, and the division didn't exist during that period.
Okay. Okay, thank you. Question number 2. Did DA Early discuss with you at any time regarding his consultation with Mr. Kiley and Mr. Kiley's advice as to how to handle any ethical or conflict issues related to Judge Bebold or his daughter with the criminal proceedings?
Yes.
Okay. Okay, so you did discuss, do you want to?
Not at the time it happened.
Okay,
Question, I think the question was ever, I think as you read it, I think the question was ever.
okay, did DA Early discuss with you at any time regarding his consultation with Mr. Kiley and Mr. Kiley's advice as to how to handle any ethical or conflict issues related to Judge Bebold or his daughter with the criminal proceedings? That's how it's.
Yes, I would just like to add this for the record, because as attorney for the Commonwealth, I do have an obligation to the district attorney under Suffolk Instruction versus DCAM.
Okay,
I have a duty of confidentiality for any thing that he has said to me in connection with this, but he has waived that with respect to these matters as far as that question goes. And he did tell me that conversation took place with Attorney Kiley.
okay. Okay, the next and last question. In 2017 in Worcester, state police, as a matter of practice, attach police reports to applications. Did you instruct this group as to your preferred brevity approach of not using a police report as a statement of facts?
Would you mind reading that?
Sure,
again?
you know,
I'll
just give it to you and.
Okay, the first part of the question isn't, it sounds like a statement, not really a question. It says in 2017 in Worcester, state police, as a matter of practice, attached police reports to applications. That's not true. Our detective unit, as a matter of practice, never attached police reports to complaint applications, as far as I know.
Okay.
And in fact, we would work with them to draft statements of facts to address all the concerns I've mentioned before. But there's 2 different types of state police in our county. There are the state police assigned to our detective unit, and then there are the itinerant state police that will roll through the county from time to time. That group, I did not address specifically. I addressed the chiefs of police, and there was a state police representative there, by memory, state police representative there. So did I address all of the itinerant state police who roll through the county? No, I did not.
Okay.
So I think that addresses the second part of the question. Did you instruct this group as to your preferred brevity approach of not using a police report as a statement of facts? So did we reach all 2,000 members of the Massachusetts State Police? No, and that's why the MDA letter was put together to try to get the Secretary of Public Safety on board to make sure that all police, whether they're assigned to our office or if they're itinerant, rolling through the county, that they all know that we should not be attaching full reports
Okay,
to the complaint application.
okay, thank you very much. No
No
question.
need to follow up on those.
Scully, you're excellent. You said you're going to be done at 4. It's 4 o'clock. You are,
I can take a hint sometimes.
Mr. Burke?
I lied.
You lied. Okay, never trust the lawyer, right? Okay, Mr. Burke is,
Just in response to one of the commissioner's questions, Judge.
okay.
Good morning, or good afternoon, sir. The commission asked you a question regarding the potential for conflict of interest. Remember that? Can I have the
Can I have
question?
the question? I'll just get the question and I'll show it to him if, Are you referring to, did District Attorney Early ever ask you in your capacity of Chief of the Integrity Unit? Is that the question you're referring to?
If there's a conflict of interest, that's what I was interested in.
Yeah, that's, can I have the other one? And he said, oh. Do you want to take a look at these? It's did DA Early discuss with you at any time regarding his consultation with Mr. Kiley and Mr. Kiley's advice? Is that what you're referring to? No. Did District Attorney Early ever ask you in your capacity as Chief of the Integrity Unit as to the possibility of a conflict of interest as to Judge Bebold or his daughter and how he or the office should proceed during the week of October 17-20, 2017 as to Ms. Bebold? Is that,
That's it, Judge.
that's it, okay.
So, the question, I don't recall what your answer was.
He did not discuss it with me, and I was not the chief of the division at that time, and the division didn't exist at that time.
All right, regardless of whether you talked to him or not, there's recognition that there's the potential for conflict, wasn't there? Let me put it another way. Was there a special prosecutor assigned to the case to prosecute Ms. Bebo?
Asking me if I knew at the time,
Well, do you know now?
I know now, but no, it wasn't a special, it went out to another county, I thought.
Okay, all right, so put it this way, there was nobody from the district attorney's office in Worcester who prosecuted Ms. Bebo, was there?
Prosecuted it to the conclusion, no.
Somebody else to avoid any appearance of conflict of interest.
That's my understanding, yes.
So regardless of whether Joe Early asked you or not, you did it by having it referred to an outside agency for prosecution.
Objection.
Isn't that true?
What's the objection?
This witness has not testified that he referred anything anywhere.
Okay, well
I
then you
just
can.
said that, regardless of whether he did.
Okay, you
That's
can
my
have it.
understanding. I didn't know at the time, but that's my understanding of how it all unfolded.
That's it, thank you.
Thank you. Ms. Friscone?
I have nothing wrong.
Very good, a man of his word. Mr. Bourgeois?
Yes, I do. Hello, Mr. Hodges. You and I haven't talked before, have we?
I don't believe we have. I think we may have, as in connection with a subpoena, I think. I may have spoken with you on the phone years ago in a civil case.
Okay, that's probably true. I'm going to ask you some questions in a different way to help us understand both the ethical and practical issues that you've talked about. And what I'd like to do, if I can, and you may need a minute to think about this, I'm going to give you a hypothetical situation, which has the elements of what we're dealing here, but it's a little bit different. I want you to think about a hypothetical situation where there are some arrests made in a gang sweep. And let's assume that related to the gang sweep are issues involving drugs and firearms. You with me so far?
Yes,
And I want you to assume that after the number of the members of the gang are picked up and they're booked, during the booking process, the arresting officer finds out that one of the suspects arrested is the son, not the daughter, but the son of a local politician. You with me so far?
yes,
Now, let's also assume that because that officer has realized that he's arrested the son of a local politician, he becomes concerned or worried, and he makes the decision to fortify the arrest report with every single detail, every single quotation made by every gang member, and put in every fact that tended to indicate the guilt of everyone. You with me so far?
yes,
And let's also assume that that arrest report containing all of that information winds up in the probable cause statement and in the public domain. Now, with that hypothetical set of facts, I want to ask you generally, and then I'll ask you some specific questions. What are the ethical and practical problems that that decision by that police officer makes for your office in the prosecution and the situation?
Objection.
Your reason?
Several. One, it's an improper hypothetical. Two, this witness has not been designated as an expert. Three, calls for facts that are not in evidence. And if I didn't say, I already said cause for speculation. It's a completely inappropriate hypothetical
Well,
for this witness.
you know, I've given the parties great leeway, mainly out of deference to my fellow commissioners, so they can hear all the evidence and they can make the decision what's relevant and what's not relevant. So I'll just continue doing it. I think I did it for you. I'll continue doing it here. So I have a feeling you're going to ask the court reporter to repeat that question. So,
Actually, the question, I remember it because I wrote it down, and that is, what are the ethical and practical problems that that officer's decision makes for your office in the prosecution and handling of that case?
I would be fine with adding or making a fulsome report. That's what I instruct people to do when I go out and do these trainings. Prosecutors want all the facts in the report. As I always tell people, we're not afraid of the facts. Facts are what they are. If they help the Commonwealth, that's fine. If they don't, that's fine too. Put them in. Put all the facts in. Statements, put them in the reports. Put them in quotations. Put them down verbatim, what witnesses say. Absolutely, that's entirely proper, it should be done. Because it's not the officer's decision as to what's ultimately going to be admitted in court. That's going to be up to the lawyers to offer evidence. It's going to ultimately be up to a judge to decide what comes in. But it should absolutely be in the report. Where I have the problem, though, is when that document enters a public file in court. That's where I have a big problem with that. And if a government agent of some sort, police officer or whoever, is taking a document that's not public, a police reports are not public. If you take a non-public report and you intentionally put it into a public file to cover yourself or to be vindictive or whatever, that is not only unprofessional, but it's illegal and in my judgment, potentially criminal.
Let me ask you some more specific questions, if I can, about this hypothetical situation, okay? Is it possible that the quotation in detail from individual people in that situation could put lives at risk?
Continuing objection.
I realize that, and
Thank you.
it's not a bad objection, but given my policy of letting everything in for consideration by my fellow commissioners, I'm going to allow it. So.
I'm not quite sure I understand the question.
I used a gang situation, and my question is detailing the information in the quotes as to what different suspects may have said, can that put the lives of witnesses at risk?
Not if it's only in the police report, because that will never see the light of day, or
But
should.
if it's in the probable cause statement,
If it's put in the public file, then it's a problem, yes.
can it cause witnesses to remove themselves from the jurisdiction, to disappear?
Yes, that can happen.
And does the use of quotations as opposed to summaries create special problems under rules 3.6 or 3.8?
Not if it's in, not just putting it in the police report, that's not a problem. And that I would encourage.
But in the probable cause statement, do the quotes create problems under those rules?
Yes, because as I believe I testified to before, statements of the accused should never be put in a public file unless it's essential for probable cause. Like that's
And-
all the evidence you've got that links this person to the crime. Then you put it in. Otherwise, it shouldn't be going in.
And do these problems exist and need to be remedied regardless of any favor or friendship with the suspect's father, who's a politician?
As lawyers, yes, we have a duty to remedy a problem when we see it.
Right. Thank you. Nothing further.
Thank you. Okay, Ms. Pruitt, the floor is yours, ma'am.
Good afternoon, Council.
How do you do?
Well, how are you?
Fine.
You testified on direct examination that it's the policy of the district attorney's office not to have the police narratives attached to the probable cause statements, correct?
Correct.
And the district attorney's office doesn't draft police narratives, right?
That's not correct. Oh, I'm sorry.
Yes, I said police narratives.
For a police report, that's correct.
Now, and the police department, strike that, and the district attorney's office does not write statements of fact. Isn't that also correct?
That's not correct.
When did District Attorney Early speak with you regarding his consultation with Mr. Kiley?
Couldn't give you an exact date, but it was sometime after the lawsuits were filed, because that's when I became involved in the case.
What lawsuits?
there were lawsuits that were filed in connection with this whole matter, civil actions,
Are you referring to the federal actions or the state actions?
well, both.
Both.
So it was sometime after that.
You testified you're a current employee in the district attorney's office.
That's correct.
Serve at the pleasure of the district attorney.
That's correct.
He is your boss.
Yes, he's my boss. That's correct.
Assistant District Attorney Travers is also your boss.
Yes.
You want this defense of this adjudicatory proceeding to be successful?
Depends on what you mean by successful, I suppose.
Well, you want them not to be found to violate the conflict of interest law, isn't that right?
I want justice to be done.
Did you not understand my question?
I understood it.
So it was a yes or no question.
It's not my decision.
Understood. But my question is, you want the defense in this adjudicatory matter to be successful, correct?
Does it require a yes or no, Judge?
Well, he did answer it. He wants justice to be done. I think that's his answer. If you want to, explore that, feel free to. But I think he did answer your question. But feel free to ask whatever other questions you want.
Thank you. You have in fact assisted in the defense of this matter, haven't you?
I think there is a common defense in the sense that the interests of the Commonwealth are at stake here as well, because I believe a decision by this commission may affect how we prosecute our cases going forward. It may actually impair how we prosecute our cases going forward.
Might I have my question read back?
You have in fact assisted in the defense of this matter, haven't you?
I think I answered the question.
He gave an
Sorry,
answer.
you can't answer the question, or are you asking if you can answer the question?
I believe I answered the question.
Have you assisted in the defense of this matter, yes or no?
You have to ask the defense. I've provided information to them as they have requested. I don't know if it's helpful or if it assists them or if it doesn't.
Have you provided a legal analysis in this matter?
I provided some notes, yes.
The sentence, let me read a sentence to you. I'll ask you if you're familiar with it. Defense of all centers on one unifying concept. The trooper submitted the wrong document with the complaint application in the public court file. Did you write that?
I did.
Did you review the interview of Major Anderson? The interview of Kevin Burke with Major Anderson?
Interview of Kevin Burke with Major Anderson. I'm not sure if I did.
What did you review?
I've reviewed a number of things. Attorney Kiley has provided information throughout this process and asked me follow-up questions about it. I've answered them.
You've provided legal analysis in this case.
I believe I have provided factual answers to the questions that have been asked.
Did you write the sentence, in his interview on January 29th, 2018, State Police Captain Robert Johnson explained the difference between a gist and a narrative report?
Yes.
You wrote that sentence, okay. Would you agree that Colonel Gilpin wrote a letter to Trooper Sevier indicating that his report was fully consistent with his training and experience?
That sounds familiar. I don't know if I've ever seen the letter, but I think that does sound correct.
Let's,
Can we just clarify, Judge, when he says that that sounds correct, that he's referring to the fact of the writing of the letter as opposed to the
The
content
yeah.
of the letter?
Okay, that's fair enough. So when you're saying it sounds correct, what is it you're referring to?
My memory is, and I think this is just from media accounts, is that Colonel Gilpin was supportive of the way the police narratives were written. That was the question.
I'd like for the witness to be shown Exhibit 41, which I believe is his outline.
Okay, Exhibit 41.
And directing your attention, I'm not sure if we have the same stamped pages. But your outline statement of facts controlling the flow of information, do you see that document?
Do you want to point it out to him so we're all on the same page, literally and figuratively?
Yes, I see it.
Approach?
Mine is 3752.
It should, yeah, sure.
Definitely have the different. So I'm looking for statement of facts controlling the flow of information. That might be the page before. Yeah, that's the page before. All right, and this was part of your presentation to the Central Massachusetts Chief of Police Association.
Yes,
You prepared this outline in May of 2014,
I did.
and you used this outline for your presentation.
I did.
And in your outline, midway through the page, it says practice varies, not included in all cases. Some departments attach reports. Did I read that correctly?
You did.
And by attach reports, you mean police reports?
Yes.
Directing your attention to the next page. My brother counsel pointed out on the next page that you put in all caps, never attach police narrative. Did I read that correctly?
Yes, you did.
The word directly prior to never attach a police narrative is recommendation, isn't that right?
Yes.
So this was a recommendation that you were making, correct?
Because of what I had said about, yes, that is
You were
correct.
making a recommendation, isn't that right?
That's correct.
It was not a requirement, correct?
Because of, as I said, chapter 38, section 4 applies only to unattended deaths where we could make a requirement, an absolute, this is what you have to do.
Mhm.
But we don't have that same statutory authority when it comes to dealing with other cases. So we have to persuade the police why they should do it a certain way.
So it's a recommendation,
Recommendation.
and it's not a requirement, except in the limited circumstances you just described, correct?
That's correct.
And it's not something that the state police is required to follow, except in the limited circumstances that you just described.
Not required in the sense that we can't order them to do it. But once the case gets to court, it's entirely in the hands of the prosecution, and we can do with that case what we wish, including null processing it. We're not satisfied that it was done correctly. So we do have some leverage, but we are careful about how we exercise it.
So I want to make sure that your testimony is clear and that your outline is clear. In terms of attaching a report, that is a recommendation that you made to the the police departments that you were addressing. Isn't that correct?
Yes,
And it was not a requirement except in the limited circumstances you just described for the police departments.
in a legal sense, correct.
It is also not a requirement for the state police except in the limited circumstance that you just described.
They don't-
Correct.
They don't have to do what we recommend, that's true.
Thank you.
They do it at their peril.
Thank you. Your outline does not say that a statement of facts should only include the elements of the offense, does it?
It does, but it's in the notes.
Your typed
No, the hand,
typed outline does not say that the statement of facts should only include the elements of the crime, does it?
in the typewritten portion, I believe that's correct.
Thank you. Now, 4 years, nearly 4 years after your presentation to the Central Mass Police Association, you wrote a memo about complaint applications to the district attorney. Isn't that right? January 19th, 2018? Do you need to see this? Do you need to see your memo?
That'd be helpful.
Why don't you pass it? I need one. Me too.
I might not get one.
I'm showing the witness a memo that he wrote to the district attorney.
No, this is not something that's in evidence thus
No.
far. Okay,
No,
I just want to clarify.
but it was produced and discovered.
Okay.
Do you see this memo that you wrote to the district attorney dated January 19th, 2018?
Yes, I do.
Okay, and that was nearly 4 years after your presentation to the chiefs of police, isn't that right?
Yes, it was.
And this was at or about the time that the Attorney General's office was investigating the changes to the arrest report of a judge's daughter.
I don't know if I knew that at the time, but I believe I believe that's correct.
And I believe you said, oh, no, strike that. Directing your attention to the second page of your memo to District Attorney Early, under analysis. The last sentence of that paragraph, the first paragraph.
Yes,
You stated the facts on which the complaint application is based may be memorialized by a probable cause statement or by a police report. Did I read that correctly?
partly.
I'm-
That's not me saying that. What I cited was Mass Rule Criminal Procedure 3G1 comment. That's where I got that from.
Okay, thank you. On page 3 in your conclusion, next to the last sentence in the first paragraph, you stated that yet some local police and other state police units do not follow this preferred procedure and continue to attach reports 2 complaint applications. Did I read that correctly?
You did.
And so what you're describing here is a preferred procedure not to attach the arrest reports. Isn't that right?
I reference a preferred procedure, correct?
Correct. It's not a requirement. Correct?
Yes, correct.
It's not something that the state police, which you specifically reference, is required to follow. Isn't that right?
That's correct.
So 4 months after that, you wrote another memo. And this was a memo to file.
Can we just have the date of that memo, please,
Sure.
just so it's clear?
April 19th, 2018. No, you don't need to. Need a copy? I'll pass it down.
You're gonna hand the witness something, you need a copy.
I am. I'm gonna show the witness, your memo to file dated April 19th, 2018. And I'll ask you to take a look at it. Oh, you've had an opportunity to review it. Okay, great, thank you. Now, so this memo is to file. What file is this memo to?
If I'm not mistaken, I believe Attorney Kiley asked if I could explain what that presentation was about on May 13th, 2014. So I just wrote this up and put it in a file to maintain it.
Did you provide a copy of this memo to Attorney Kylan?
I believe I did. I think he requested it.
Why is it, and the memo's not written to Attorney Kylie because what?
I think I was just memorializing it to maintain it as a file in the office, that this was my recollection as of April 19th, 2018, of the presentation I gave on May 13th, 2014. I know what it was. The file I put it in was my presentation file. That's what I put it in.
So Attorney Kylie asked you to draft a memorandum regarding a presentation that you'd given 4 years earlier, is that?
Not exactly. He asked if I could explain the what was in the outline, like presentation I gave, if I could relate what the presentation actually was, because the outline was not sufficient for him to understand, I think, what went on with the presentation. And there was no video recording of it or anything like that.
And at the time you drafted this memorandum to file, the Attorney General's office was still investigating the changes to the arrest report of the judge's daughter?
Oh, I don't know. I don't know if I was aware of the Attorney General's investigation.
Okay, so let's just finish up with this memo. And then we'll go back to what you knew when you knew it. So in your memo to file, on page 2, under practice varies, not included in all cases, some departments attach reports. Do you see that?
I do.
And you wrote, there's a lack of uniformity in how police officers apply for complaints. Some attach probable cause statements to complaint narratives. Strike that. Some attach probable cause statements to complaint applications, while others attach police reports that contain narratives of police officers detailing the facts of the case, sometimes called police reports, incident reports, arrest reports, summary reports, narrative reports. Did I read that correctly?
You did.
And again, if you just skip down to the last paragraph in that section, it says, the district attorney's office prefers that officers take the time to draft a brief probable cause statement and attach that to the complaint application. Did I read that correctly?
You did.
And again, that's a preference,
Yes.
also a recommendation,
Yes.
not a requirement,
No.
and the state police doesn't have to follow it.
That's up to them. Like I said, they do it at their peril.
But state police has counsel, correct? State police has a general counsel?
Yes, I've dealt with them before, sure.
I'm gonna show him this. Unfortunately, I don't have additional copies of it.
I'm not sure that this isn't in. No, it's not in this
No,
one.
you removed it.
Yeah.
You removed that page.
Did I put it, isn't it in the disputed exhibit?
I'm not sure you did.
I have no objection to you showing it to me.
Okay. I am gonna show you an email from you to Attorney Tom Kiley dated February 6, 2018. And I'm gonna ask you if you could take a look at that email. That's an email from you to Attorney Tom Kiley.
Yes.
That email related to the production of certain documents that you made to Attorney Kiley.
Yes.
And that included your materials that you prepared for the trainings and to the police chiefs and the like, correct?
Correct.
And you were providing that information during the time that the Attorney General's office was conducting their investigation into the arrest of the judge's daughter.
Yeah, I don't recall knowing, I think that was all done pretty discreetly. I don't think people in the office knew it was an Attorney General's investigation. I might be wrong about that, but I don't really have a memory of that. And yeah, I don't recall that at all.
You don't recall knowing that there was an investigation being conducted by the Attorney General?
I recall knowing there was a lawsuit that was pending, I believe, this time. A couple of lawsuits. I think this request, Mr. Kiley was requesting information in connection with the lawsuits. That's my memory of it.
Thank you.
Did you want all that?
Yes, please. Thank you.
have no further questions.
Ms. Pruitt, yeah, are you, I don't care what you do, I just want to remind you, are you planning to introduce any of the documents you were referring to? It's entirely up to you, I don't care. No?
thank you.
Okay, thank you. Okay, Mr. Kiley, you have any, anything? You realize no is an
I have
acceptable,
a couple of questions.
no is an acceptable answer, you realize.
There are a lot of Tom Kileys in the world. Do you know which Tom Kiley you were communicating with?
Yeah,
Was it me?
yes.
With respect to the couple of lawsuits, Joe Early was a defendant in a lawsuit. Who was his lawyer?
Tom Kiley, you.
Were special motions to were a motion to dismiss and a special motion to dismiss filed in that case?
There were a number of motions, and I believe those were, yes.
Is it your understanding that anybody owns a witness?
I have always been available to anyone who asks questions. No one from ethics has ever contacted me.
With respect to the documents that you were just asked about, one of them, that is not admitted, has a note up in the top, attachment 6. Did you put attachment 6 up there on the document? I'll show it to you.
Just so we're clear, what document are you?
It's one of the ones she showed him.
Okay.
Oh, this says to file from me regarding I wrote up a memorandum of my memory of my presentation from 4 years before. It says attachment 6 typed on the top. I did not type that.
Down at the bottom, there are Bates numbers, correct?
Yes,
Did you put the Bates numbers on there?
no, I didn't. And I would also add, as I said before, I always print on one side of the paper. So this is, although this is the text I wrote, this is not the format that I would have written it.
We're on the subject of this document while we were talking about what you just had in your hands. Strike that, strike one. The fact that you never contested that all the police departments don't follow your policy, have you?
Contested it, I've said that. That's what the problem was.
Well, what you said today on multiple occasions is police officers do that at their peril, correct?
Yes.
What do you mean by that?
If they submit a document into the public file that shouldn't be there, then the prosecutor can take remedial action up to and including null prosing the case, bringing it to an end, and not prosecuting it further. That is an option. We do not have to prosecute every case that comes in, can decline to prosecute.
And if you were to null pros a case in the district court, does jeopardy attach?
No, because, no, jeopardy doesn't attach.
And what would happen is that another application for complaint could be filed, correct?
That's correct.
That met your policy, correct?
Exactly.
Your position is the wrong document was filed here, correct?
Yes.
And it's wrong in your mind because it contained materials that were inconsistent with the rules of professional conduct, correct?
Inconsistent with the rules of professional conduct, inconsistent with the policy as dictated by District Attorney Early, and inconsistent with his overall policy of treating people with compassion within the bounds of the law. Yes.
And with respect to the materials that you looked at that have not been admitted, the policy of the office with respect to complaint applications and statements of fact has not changed since this incident, has it?
The policy has not changed, no.
And in fact, you have sought to make the policy a part of the uniform practices throughout the state, correct?
It's my understanding that all of the district attorneys, through the District Attorneys Association, has adopted the policy that has been in place in Worcester County on complaint applications.
You know the case of Shepherd versus Maxwell, don't you?
I do.
What does Shepherd versus Maxwell stand for?
Excessive pretrial publicity can result in a conviction being reversed.
You know that there are special responsibilities for prosecutors, correct?
Yes,
It's not a recent invention, correct?
that's correct.
We've been proclaimed ministers of justice for many years, correct?
Correct.
And that is because we have special responsibilities. It's no longer we. The special responsibilities exist because prosecutors are ministers of justice, correct?
Yes, I would suggest it even goes beyond that, because at least in Worcester County, and this is what I tell people when I go out and speak with them. I cite, I know the case you're referring to, but I cite another case Chief Justice John Marshall wrote in United States versus Wiltberger, 18 U.S. 76, 1820.
Did you put that in one of these memos?
No, but what he said is our entire justice system is based upon a, quote, tenderness of the law for the rights of the accused, unquote.
Thank you.
Your memorandum dated May 13th, 2014. Pretty good memory.
I'm sorry, which memorandum is this?
The one of May 13th, 2014. What about raking leaves in the front yard?
Oh, right, yes.
Objection, I don't think when he handed the waivers is dated May 2014. I think it's dated either January or April of 2018.
It is dated April 19th, 2018.
Thank
and it's
you.
referencing the presentation of May 13th, 2014.
Okay. So we got one date right. In this document, you wrote this, right?
I did,
Love the law?
I do.
How many times do you reference the importance of maintaining the integrity of the case? Do you know how many times you do that in this 4-page?
I'd have to read it.
Let me tell you. Page 2, carry it over to page 3. Page 5, we have a responsibility to enforce the law with integrity. In the last page, by following these steps, you will be enforcing the law and protecting the integrity of cases. Just not for the office in Worcester. Is that important for you as a prosecutor?
Yes,
And you've read this report, haven't you? The arrest report of Valley Bebo,
yes,
based upon your training and your experience. How many years as a DA?
27,
How many cases do you think you prosecuted?
350 in Superior Court.
Based upon your training and your experience, is there any justification for the inclusion of those documents, those sentences that were deemed to be salacious and or inappropriate to establish probable cause?
Objection.
There you go.
I believe it was entirely appropriate for those statements to be included in the narrative report that the trooper wrote. It was entirely inappropriate for that to be submitted into a public file in the court.
Because that would have resulted in potential pretrial publicity to the accused, would it not?
It did.
On that slender reed that law is based upon. Isn't that true?
I'm sorry.
What was the quote you used from Mr. Justice
Oh,
Marshall?
yes. It was definitely not, it was not a tenderness for the rights of the accused.
Thank you.
Ms. Rossini, you have any questions?
No, I don't.
Okay. Okay. Mr. Bourgeois, you have any questions?
I'm going to resist the temptation to get in the last word. No.
Okay, thank you.
I can't resist.
Okay. Okay, Ms. Pruitt, you'll have the last word, ma'am.
I only have two questions for you. The first one, there's no risk of trial publicity on a case that's not going to trial, isn't that correct?
I'm not sure I understand that.
Sure, a case that's not going to trial does not risk trial publicity, isn't that correct?
No, it's not going to trial?
Correct.
I'm not sure you ever know a case isn't going to trial.
You're not answering my question.
I don't understand it.
There's no risk of trial publicity on a case that's impounded.
That's not true.
Sir, thank you. I want to thank all the parties. It's been a long day, and I'll see, can I just, we have Wednesday, Thursday, and Friday next week. So just, can you give me a roadmap of what we expect and just alert the petitioner, or if you haven't done that already, about what's
I
the,
thought that our lead witness on, I had thought that our lead witness on Wednesday would be Mary Beth Adams. I'm informed that she has a funeral she's going to attend that morning. So we're going to scramble to give you who's going to be first. I understand that Mr. Risting is back. I think he's going to be called.
who's that?
Colonel Risting.
Okay, Colonel Rich, okay.
But what we will gather and give them first and then you a batting order after we've been able to juggle our various witnesses.
I'm more concerned with,
And again, I'll let them know in advance.
I'm more concerned with you providing that information to the petitioner.
I will, but it also, we have proposed a stipulation or a document. It may change things. There's something going on between us. It may change the batting order as well.
The us being the respondents or including the petitioner, oh, okay. Okay, so if that's it, hope everybody.
Just a moment, please. We need to know by a date certain who's going to be called on Wednesday. And we need to not know on Tuesday night or Tuesday morning. We need to know there are 4 respondents. They've had the opportunity to get their witnesses lined up. We need to know who they're calling.
Did you listen to yourself when we were here before? We will let you know as soon as we've sorted out among the 4 of us.
But she wants to know, obviously, sooner than later, which is fair with us. So if you can just give her a list of the witnesses as soon as
I will
practical.
do so. I
And
don't control the death of, that somebody's gotta go to a funeral.
And Ms. Pruitt, if you feel that you're at any disadvantage, please let me know. We'll try to address that.
Can they be required to provide us with a list by the close of business on Monday at the latest?
Well, it seems fair enough by
I
Monday.
certainly will try.
You're right, if I could
That's
just-
unacceptable.
If I could just point out, I told petitioner at least once, perhaps twice via email, that Christine will be on Wednesday via Zoom. And obviously, this funeral situation changes whether it'll be first or second.
Okay,
And it won't be at 9:25 in the morning, like happened when we showed up and were notified that the witness was going to be called at 9:25 as I was walking from the train station to here.
okay. Well, let's-
9:26.
Okay, well, I want everybody to have a safe and wonderful weekend. And I will see you all next Wednesday.
Thank you, John.
Mr. Kantrowitz, can I raise a quick question?
Oh, okay. You know, it's like Godfather 3, every time you think you're out.
I know it's late, so I would just ask you to think about this, but one of the things I've realized today, participating remotely, is that when the petitioner on cross-examination is using a document, I can't see it. And it's a little bit unfair because everybody in the room can see the document and point out other parts. So
We can
if we could
address
take-
that.
if we can address that next week, I'd appreciate it.
Yeah, we can address that. So, and I apologize to you. I should have asked you whether you can see that document. We'll make that, we'll address that.
Thank you.
Okay, thank you all.
Thank you.